My lord, supplementary 54 my hearing.
Yes,
Today, division bench also arrest.
time may not permit.
Yes, therefore, my lord, there is one IA application is there for injunction. May I lord kindly fix it on 9th or 10th December. 9th is Tuesday, 10th is
Who is for the other side?
we will already informed.
On request of learned counsel for the parties, let this matter be listed on
10th.
10th of December.
Grateful.
May I please, Your Lordship? I beg to mention item number 24, Your Lordship, for order, with the consent of other side, Lordship. And I am on behalf of Mr. S. Ali, and he is not well, Your Lordship. So the matter may be adjourned for the day.
Item number,
24, Lordship. Order.
what is your name?
I am on behalf of S. Ali, S. Hussain. I am S. Hussain.
Heard Mr. S. Hussain, learned counsel for the petitioner who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner, Mr. S. Ali. Learned. He submits that he has informed learned counsel for the others respondent regarding his prayer for adjournment, who has no objection to the same. Hence, the prayer is allowed.
After 2 weeks.
Let this matter be listed after 2 weeks.
I love that.
This is a matrimonial appeal, my lord. Here, my lord, delay has been condoned, my lord. Thereafter, it was, there was an order for listing the matter for admission, but it was not listed after. There was an order dated 9/5.
Next week,
My lord, and there was, my lord, both the
when
parties
you
were,
want.
my lord, on Thursday, my lord.
Okay, okay, on Thursday.
May I please, Russia, beg to mention for listing of one interim application, Milord. In this case, Milord, their RS was filed with a delay of 8 to 1 days. In the meantime, execution proceedings has been started. Let the matter maybe your lordship.
Delay has been condoned.
Delay has not been condoned. In the meantime, execution proceedings started, Milord. 8 to 1 days delay, Milord. The lordship will fix, allow me to move the matter on 28th of this month.
Okay.
May it please, my lords. My lords, I'd like to mention item number 12. With the consent of the other side, my lords, I'm praying for a short accommodation. I'm led by Mr. Senior Counsel, Mr. I. Chaudhary, my lords. He is in some personal difficulty today. Can the
What is your name?
B. Chaudhary, my lords. Can the matter be taken up on 19th, my lords?
No fixed date.
24th then, my lords?
No fixed date.
The execution proceedings have
No,
been started, my lords.
we'll fix the week. Heard Mr. B. Chaudhary, learned counsel for the petition, appellant who prays for an adjournment on the ground of personal difficulty of the conducting senior counsel for the appellant. He submits that he has informed the counsel for respondent regarding his prayer for adjournment, who has no objection to the same. Let this matter be listed. In the next week on a date to be fixed by registry.
May I please, Lord? But I'm praying for listing of a case for admission, MSA appeal, Lord, on Wednesday, Lord.
Okay,
I love.
Let is
only one civil bench.
Also, I beg to mention for listing of an RFA. Can we fix on next week or the first week of December?
First week of December.
First of December.
With the consent of the other side, Lordship, I beg to mention item number 39, Lordship. It is for orders, Lordship, but the dealing counsel, Ms. R.D. Majumdar is out of station.
39.
We have filed an I'm for the applicant respondent, my lord. Not, I have not received a single penny, my lord, after admission, my lord. So we are praying for a direction to deposit the 50%, my lord. Matter is still urgent, my lord. Can it be on 21st, my lord?
Heard Mr. S.P. Sharma, learned counsel for the item number 30.
39, Lordship.
S.P. Sharma, learned counsel for the respondent who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the respondent, Ms. R.D. Chaudhary, R.D. Majumdar. Also heard Mr.
V.K. Borrow, my lord.
V.K. Barua. Who prays for listing this matter on
21st, my lord, Friday.
21st as an interlocutory application has also been filed by the appellants. The prayer is allowed. Let this matter be listed on 21st of November.
May it please your lordship, I pray for listing on RSA method on 19th.
No fixed date.
Lordship, the respondents may start the execution proceedings soon.
May,
Yes, yes, your lordship. On 19th of November. We have prayed on stay application also.
next week on a date to be fixed by registry.
My lord, please. My lord, I am mentioning few IAs for withdrawal of the money, my lord, and 2 IAs for the, my lord, for conversion of delays, my lord.
When have you filed?
My lord. The
When?
IA for the, I am for the respondent side, my lord, in the conversion of delay, my lord, those are filed in sometime in the month of September. But those IAs have not come yet. What I'm praying, my lord, in the case of those conversion of delays, my lord, it can be taken any date, my lord. I generally do not have an objection to this, the delays condoned, my lord. If if that can be taken on 21st, my lord, if it is convenient to this honorable court.
No, not this week. First week of December.
My lord, please. My lord will indicate a date, my lord, if please.
No, let registry.
My lord, please.
Please, your lordship. In item 7, we have filed an affidavit, but it is not tagged, my lord. Maybe we are permitted to bring it or any
Yes.
other date, your lordship.
Item 7,
Yes.
you want an adjournment.
No, I don't want adjourn, my lord, but I have filed an affidavit. Without affidavit, how your lordship will consider it? It is not tagged. Of course, I filed it Saturday, that's why.
Okay, let it be brought on record.
Then any other day, my lord.
Let the other side remain present.
I tried to contact, I could not contact.
It is item number 7, we will pass orders.
May it please your lordship, I beg to mention for listing of an IA in a civil revision petition.
What I,
It was for a correction in the last order. The year of the title execution case was mistakenly written. A small correction,
when do you want?
Tuesday, tomorrow, if possible, your lordship.
No. Day after tomorrow.
Please.
Wait, lordship. Lordship, pay for listing lordship, for withdrawal lordship. Day after tomorrow, lordship.
Okay.
May I please your lordship, I beg to mention item number 1. Arvind Council has been some difficulties.
Item number 1. What is your name?
K Das.
Heard Miss K. Das, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Considering the ground, the prayer is allowed. Let this matter be listed
Right.
in the next week on a date to be fixed by registry.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 17, lordship. My senior counsel is not keeping well. The lordship may kindly adjourn the matter and
Heard Mr. And what is your name? Your for, heard, heard Miss K. Bora, learned counsel for the respondent who seeks an adjournment on the ground that conducting counsel for the respondent is not keeping well. She submits that she has informed the learned counsel for the appellant regarding her prayer for adjournment, who has no objection to the same. Hence, the prayer is allowed.
for 2 weeks.
Let this matter be listed after 2 weeks.
Date may be given. Item number.
No, no. date.
May it please your lordship, I beg to mention for the other listing of bail application, lordship.
Bail
I-
application before the criminal bench. No, before criminal bench. This is civil bench. And before appropriate bench.
May it please your lordship, I beg to mention an FAO for listing, your lordship, any date next week.
First week of December.
Obliged.
Please, your lordship. Actually, I'm paying for listing of 2 matters. One is for IA, for delay condemnation, and second is appeal lordship. For orders, Friday lordship, if possible.
No, No, next week on a date to be fixed by registrar.
May I please, your lordship, I beg to mention for listing of two matters, lordship, both are MSc epic lordship. For orders.
Next week on a date to be fixed.
May I please, Lordship, I beg to mention item number 27, my lord. On behalf of 27, on behalf of KM Hassan, can you adjourn the matter for the day, my lord?
What is your name?
J. Ahmed, my lord.
Item 27. Heard Mr. J. Ahmed, learned counsel for the petition. Appellant who seeks an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed.
Yeah, please, your lordship, I beg to mention for listing of a CRP order. And it is fixed on 28th, my lordship. I
Next
filed
week.
it on 15/11/2020.
Next week.
My lordship, there is some urgency. It is fixed on 21, your lordship. I have come against an order, impugn order, whereby the evidence was closed, your honor. So we could not cross. So it was fixed on 20th, and it will be fixed for DW.
When you want,
28th.
Okay. 20.
I'll be obliged.
May I please, your lordship, I beg to mention for listing RSC,
First week of December.
26.
No fixed date.
49 for withdrawal.
But the matter has been amicably settled between the parties, my lord. Settling this.
Heard Mr. V.K. Borwa, learned counsel for the petitioner. Also heard Mr. A. Islam, learned counsel for respondent number 2, respondent number 1. It is submitted by learned counsel for both sides that matter has been amicably settled between the parties. The learned counsel for the petitioner therefore submits that the petitioner does not intend to pursue with this matter and prays for withdrawal of the same. The prayer is allowed. This civil revision petition is dismissed on withdrawal.
33 and 34.
Yes,
I'm for the petitioner, your lordship. I want to withdraw the petition, your lordship.
both
34.
34.
34.
Okay, Nani, huh?
34, yeah?
And what is 33?
Is the cancellation of bail filed by the informant.
Lordship, it cannot be withdrawn, lordship. I had filed the IA lordship with regard to when the original bail application, first bail application was pending before this honorable court. Subsequently, another bail application was filed wherein lordship has I filed the first one, your lordship. The first one was pending.
No, just a minute. 33, this IA has been filed.
By the informant, both the cases, one FIR, two bail application bill filed before this honorable court lordship.
I filed the first one, the second.
So second one is not maintainable lordship. While the first bail application was pending before this honorable court.
What happened in those bail applications?
First one is still pending. Wherein the petitioner is inclining to withdraw that because subsequently.
And second one?
He wants to
Another
withdraw that
person.
petition.
And what happened to second one?
Second one, he got bail. So we are here for cancellation of that bail application
Second.
in the IA. Reason is that while first application was pending before this honorable court, he cannot, in the same FIR, same grounds, he cannot file second bail application.
Whether the records are there.
Second bail application, he has filed suppressing all the facts.
What is the number of the first bail application?
First bail application lordship number is. The next. Bill number lage.
24 is the 2401 lordship. First bail application, bail application is your lordship 2029. 2029 is the first bail application and the second bail application is
2029 is still pending.
still pending. Is, and wherein
And you want cancellation of bail on 2401.
2401 lordship. 2401 was filed in the month of July. And lordship 2029 was filed in the month of June. So the earlier bail application which was pending,
Who is appearing for the respondent? You are appearing in both the cases.
No, my lord. I am appearing for the first one, 2029.
Now you are appearing for the
Petitioner.
petitioner.
Yeah.
So then no, you may withdraw, but your bail will be cancelled. Second bail will be cancelled.
lordship.
I'm not concerned with the lordship.
Okay, then let me cancel it. Miss T. Ghosh, learned counsel for the petition. What is your submission?
Lordship, he has suppressed the fact and we have a notification of our Honorable High Court, which says that while one bail application is pending, subsequent with the same cause of action, another bail application cannot be filed, lordship. So while this
Where is the where is the order by which bail was granted?
bail was granted, lordship, is it annexure, lordship? Page 11, lordship, annexure 1.
It was granted in subsequent bail application.
Yes.
And where is the first?
First is pending, which is item 34, lordship.
Item 34 you want to withdraw. We are allowing that. What is your submission regarding cancellation?
I am not engaged in that case, your lordship. I
You-
was engaged for first one, your lordship.
How it can be? You are this.
First, your lordship. I filed it it was in the month of June, your lordship. Second one is July, no?
And in the subsequent bail application, lordship, informant has not received the notice. Informant has not received the notice. This honorable court has appointed an amicus in that case, lordship. If she would have received the notice, informant, which
No,
this would
in
have
this IA whether notice has been
taken steps, lordship. Then let's wait, let a notice be served.
okay, then no notice has. Then we are not allowing withdrawal at this stage.
Yes, lordship.
Let the notice be served.
Yes, lordship. I have taken steps.
Heard Miss D. Ghosh, learned counsel for the applicant.
Informant, no? But my IA filed also. That is my informant.
No, this one is in the item number 33 IA. On perusal of the office note dated 13/11/2025, it appears that the service report in respect of respondent number 2 is awaited. The registry is directed to place the track consignment report of notice issued to respondent number 2. Respondent number 2 to speed post on the next date fixed. Stop. In the connected bail application, that is bail application number 2029. Miss A. Begum, what is your name?
A Begum.
Miss A. Begum, learned counsel for the petitioner, appears and submits that she has only been engaged in bail application number 2029 of 2025 by the petitioner Abdul Ali, and he is willing to withdraw you take instruction regarding not regarding withdrawal, regarding service hour. You inform that there is another case pending.
Not informed, Your Lordship.
You inform him, now you inform him.
Subsequently, I have
Now you have come to know
Yes, yes.
regarding pay. We are reflecting it in order, requesting you to inform the respondent.
Come.
Now you take instruction whether you will be appearing in IA or not.
I am not instructed to appear.
Take instruction. Now take instructions. क्या लिखा? Abdul Ali, who is willing to withdraw the said bail application. However, she submits that she does not have any instruction for appearing in IA criminal number 1140/2025. Stop. This court requests Ms. A. Begum to take instructions from the respondent number 2 as respondent number 2 in the interlocutory application and the petitioner in bail application number 2029 are one and the same person as to whether she may appear for him in interlocutory application or not. Considering the nature of the averments made in the interlocutory application, prayer for withdrawal of bail application number 2029 is not allowed at this stage. Let this matter be listed. When will you take instructions? How much time will you?
Oh, Your Lordship.
On 28th of November. 28th November.
Deeply obliged.
Obliged, Your Lordship.
No, nothing discussed.
Item 35. Item number 35. Item 51 and 52.
They may not have noticed that we will be taking up criminal matters first.
True.
So we'll take it up
After some time.
or in the second half.
At 2, my lord, I have got one matter fixed. Will come at 12, my lord,
Okay, after some time.
after some.
Because we have not notified criminal matter Lombuli Kwanasi. Notified.
Petition to second.
Okay. We'll take it up after some time.
Lot.
Item 2.
Yeah, please, Your Lordship. Lordship, this application has been filed against the order passed by the Labor Court, Your Lordship. The case of the petitioner is that, Lordship, petitioner was serving as a laboratory technician in the office of the respondent number 1, Lordship. Due to some allegation leveled by one employee, Lordship, a so-called notice was issued, and after inquiry, Lordship, he was terminated, dismissed from service, Lordship. Challenging that order, Lordship, the petitioner approached before the industrial labor court under industrial dispute act lordship, that lordship will find in page 20 lordship. And in that case, lordship, the respondent's authority contested the case by way of filing written statement lordship. And thereafter lordship, along with that application lordship, the petitioner filed one application lordship, wherein lordship he prayed lordship will find lordship that annexure 3 page annexure 3 page 34 lordship. In this misapplication lordship, the honorable labor court passed an interim order lordship, that relevant portion is page 35 lordship. After hearing both the sides, the interim order so granted the petitioner regarding
Where is the impugn order?
impugn order is lordship will find in page 43. In this case, lordship, the respondent number filed one application before the SAM court to pay the electricity dues of the petitioner lordship. Then the labor court lordship, after hearing parties lordship, passed an interim order that petitioner directed to pay the electricity dues lordship. But earlier there was an interim order passed by the SAM court lordship to direct the petitioner to stay in the staff quarter lordship. Then lordship, the petitioner contested that misapplication also lordship by filing written statement lordship. And in the written statement, there is a specific play was that lordship, that application filed by the respondent before the labor court to recover the electricity due is not maintainable lordship, because that court has no jurisdiction to issue past that order lordship. And moreover lordship, after dismissal from service, the petitioner was jobless. That is why he approached the labor court, and labor court has passed that interim order lordship. But without considering that, labor court has passed an order that lordship will find in page 46 why criminal proceedings should not be issued against the petitioner. Without considering. And in the application, they have annexed one.
No, what was done by passing impugn order?
Impugn order is lordship will find in page 44, page 45, page 44 lordship. It starts from page 43.
You were directed to pay electricity bill.
Yes, lordship. But in the order lordship, it is stated that petitioner is agreed with that order. But the petitioner is not agreed. The petitioner is also absent lordship. The petitioner is represented by the learned counsel lordship, and they have filed a written statement also. And written statement, they have specifically stated that he cannot pay because after dismissal from service, he become bankrupt. So after closing of the application, if any order passed, he will accept lordship. But without considering that lordship, the court has passed that order. And moreover, lordship, in the application filed by them lordship, they have annexed one statement of electricity dues pending against the petitioner. But there was no endorsement by the endorsement of the epidicial authority lordship. And without considering that also, the court has passed that order, directed the petitioner to pay the electricity dues. Lordship.
Who is respondent number 4?
Respondent number 4 is the lordship. Respondent number 4 is Parvati Upadhyay.
Who is
that
she?
lady filed the complaint against the petitioner, where the petitioner has.
And respondent number 5?
Respondent number 5 is lordship, the official authority lordship who has passed that order lordship. Approach the court lordship. Who passed that order of dismissal also lordship.
Where is the wrong in the order? What is the wrong in the order?
Wrong in the order is that lordship, to pay the electricity dues lordship, the case is pending before the labor court lordship, and the labor court has already passed an interim order to permit the petitioners to stay the office quarter. Thereafter, they approach the official authority approach the labor court by way of filing one application. That petitioner is some electricity due is pending from the side of the petitioner.
So you have to pay that due.
Lordship. But I cannot pay because lordship, after dismissal from service, I become jobless lordship, and moreover lordship, interim order, as in terms of interim order, I was in the office quarter lordship. And I have duly contested the case by written statement also.
No, if something is due from you, you were only allowed to stay in
Lordship,
the,
I'm not saying that I will not pay, but Lordship, in the misapplication, they have annexed one statement of electricity due, Lordship. They themselves prepared, Lordship. There was no endorsement of the APDCL authority also. That was also our specific stand of in the application, Lordship. Lordship will find that statement, Lordship. Page 38. Page 38, Lordship. That is the statement prepared by the office without any endorsement of the APDCL authority also.
so what is your stand? That this much is not due?
I'm not saying I was specifically stated in my written statement that is to be endorsed by the APDCL authority. There is no veracity, Lordship. There is no any proof, Lordship.
So you are denying?
Yes, yes. But without considering that case, Lordship, on the basis of an misapplication, Lordship, the court has passed to pay the electricity rule, Lordship. But the same court in the main case passed an interim order to permit me to stay in the office quarter.
No, you can stay there, but you have to pay the dues. There is no contradiction. By one interim order, you are allowed to stay in the quarter. And this order only asks you to pay the dues.
Lordship, I'll definitely pay, Lordship, but the learned court below has passed that I have agreed, Lordship, but there was no specific agreement in the case, Lordship. In the written statement also, without considering and without hearing that my written statement, that they have passed the order, Lordship. I'm not saying that I'll not pay, Lordship, but they have to hear me first, Lordship. On the basis of that application, Lordship, they have the court has passed that order, Lordship, without considering my objection also. And after that, Lordship, that page 46 order has been passed as to why criminal proceeding has not been initiated against me, Lordship.
Page 46, you are not impugning.
Page 46, I'm impugning that page 47, Lordship, order, Lordship. In the order, it is reflected, Lordship. Relevant portion is page 49, paragraph 5.
Which orders you are impugning?
Lordship, I'm two orders I'm challenging, Lordship. Page 43, annexure 6 as well as annexure 8. Annexure 6, Lordship will find in page 43. Relevant portion is page 44, paragraph 4, my lord.
But Mr.
R.K. Talukdar.
We are issuing notice.
Lordship, next date of the lower court is on 26/12, Lordship. So
We'll fix then.
so that order may be stayed, Lordship.
No stay at this stage. Heard Mr. R.K. Talukdar, Learned Counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioners, namely Debashish Das, impugning the order dated 11/9/2025 and 24/10/2025, passed by the learned presiding officer, Labor Code Dibrugarh, in industrial dispute case number 1/2024, whereby by the first impugn order, he was directed to pay outstanding electricity dues in respect of the residence where he is staying. Learned Counsel for the petitioner submits that the said order has been passed without taking into consideration and without giving the petitioner the opportunity of being heard. And by the second,
Against the objection, Lordship.
in order, you show cause has been issued.
Lordship. Second order, yes.
You,
Second impugn order. Yes, Lordship.
second impugn order,
Second impugn order, Lordship will find page 49, paragraph 5 start.
what is the grievance?
Lordship, may I read, Lordship?
You submit an explanation.
Yes.
What is there to being aggrieved? It has called for an explanation. You,
Explanation, Lordship, prior to that, Lordship, I filed one application for seeking date, Lordship, that I have approached the already honorable court. So sometime may be given, Lordship. Since at that point of time, I was not unable to produce the case number, that is why that order has been passed.
without giving opportunity of being heard. Issue notice to the respondents. The petitioners shall take steps for issuance of notice upon the respondent by speed post within 7 days from the date of this order. When is the next date?
Lordship, next date is 26/12.
On 18th, returnable on 18th of December. Let also the scan copy of the records of ID case number 1/2024 be called for from the Labor Code Dibrugarh list accordingly.
May please, my lord, here I was aggrieved by an order, my lord, by which my prayer for allowing to produce some documents has been rejected. That order is at page number 108, my lord, and it's at 18.
Where is the impugn order?
108, my lord, and it's at 18. The long order, my lord. I am the defendant of the original suit, my lord.
108.
8, my lord.
What was your prayer?
My prayer is in the petition is that, my lord, I may be allowed. I sought the leave of the learned trial court below, my lord, to grant me leave to produce some documents which is vital for my defense, my lord. That is the prayer in my petitions, my lord, and I have annexed the petition also, my lord, which is at page
At what stage the trial is pending?
in the stage of examination of defense witnesses, my lord. I have stated regarding some documents in my WS, but at that time, my lord, some documents which are not in my hand, which are missing, my lord. That time I found the missing documents. Therefore, I filed a petition under orders 8 rule 1A, my lord, and section 151.
Why you could not file it, those documents at appropriate time?
So some documents are missing, my lord, and
You have
one.
mentioned that in your application,
Yes, my lord.
that those documents are missing.
Yes. My application is at page number 100, my lord. And exam 16, my lord. In the Firesti, my lord, one document was due to mistake, my lord, not mentioned, but I have mentioned it in the WS, but other documents, my lord, regarding the other documents, which are documents B and C, my lord, For the documents, my lord, I have stated in my petition that those are missing, my lord, missed out with other documents, my lord. At page number 101, my lord,
But plaintiff's witnesses have been examined.
examine, my lord.
Now, how they will put up, they will be taken by surprise if now you are producing some documents.
Those documents, your lordship, regarding those documents, my lord, I have mentioned in the WS, my lord.
But without producing those documents, how plaintiff will make out his case?
So far, my limited knowledge is concerned, my lord, documents can be produced any state subject to the leave granted by the,
When leave should be granted?
when there is some explanation is given, and if for the inch of justice, my lord, those documents is required to be look into, my lord. And here, my lord, those documents are very much important, my lord. Regarding the sale deed, my lord,
When is the next date fixed?
19, my lord.
It may cause prejudice to plaintiff.
19 is the next date, my lord,
When is the next date?
19th of this month.
Why trial court rejected your prayer?
Trial court rejected that because the case is in the stage of defense witnesses and delay ground, my lord. This is the two ground, my lord.
What will happen because of delay?
The operative, my lord, the operative portion of the trial ground for which my petition is rejected, it is 114.
Whether any observation is that allowing the prayer at this stage may cause prejudice to plaintiff?
Yes, my lord, it is 115, my lord.
Where is the relevant?
115, paragraph 16, my lord.
Read from page,
16, my lord.
para 13.
Is the ground, my lord. Now coming to the facts of the present case, it appears that in the present case, the petitioner had not filed the documents along with the WS and counterclaim. Neither filed a list of documents stating that the documents were relied upon by them, but were not in their possession or in those possession or in whose possession the documents are. The only ground stated by the petitioner in the petition is that due to pen mistake shell agreement dated 23/5/2008, document number A1 was not separately marked in the Firesti dated so and so. Regarding other document mentioned as document number B, it is
In
mentioned.
your WS, have you mentioned about those
I have mentioned about the sale agreement 13/5/2008.
Have you mentioned in
Yes.
your WS
Yes,
that
yes.
that is not in your possession?
That was not mentioned at that time. That is my in my possession, but mistakenly it was not my lord written in the Firistian, my lord. But I have mentioned it that on the basis of this sale agreement, my lord, I got the possession of the land, my lord. That has been mentioned in my WS, my lord. I only want to produce these documents, my lord. These documents is very vital for my defense, my lord.
No, there is a procedure in civil cases that have to be followed by both the parties.
My lord, WS and the Firesti, I have to submit the documents, my lord. But in 151, section 151 and the rule on which I have, that's immense power, my lord. Court can grant leave, my lord. If those documents, court said that these documents is necessary to adjudicate the matter for the inch of justice, my lord. If those documents are not allowed to, my lord, look into by the court, if the court does not look into the documents, then I will be prejudiced, my lord.
State is a party here.
In the original, so the state is the party, my lord, so I have made them party. Lord.
Order 8 rule 1A. They should have to file this document in the time of written statement and counterclaim. But they did not file at the time of written statement. And even though they did not mention in their WS also. That's why, Lordship, my submission is that it is interim order is not, there is no any perversity in the impugn order, Lordship. As because of the delay, they are not mentioned in any explanation also not given by the
Okay, who is the main defendant?
Main defendant is respondent number one, my lord. Liakot Ali, alias Liakot Ali.
Let him appear. Heard. Mr. MAI Hussain, learned counsel for the petitioner. Also heard Mr.
T.R. Gogoi.
T.R. Gogoi, learned government advocate, appearing for
2 and 3.
respondent number 2 and 3. This application under section this application under Article 227 of the Constitution of India has been filed by the petitioners, namely Rafial Haq, alias Rabial Haq, and Imtaz Ali, impugning the order dated 26/8/2025, passed by the Court of Learned Civil Judge, Senior Division, South Salmara, in Misje case number 20/2025, in connection with title suit number 6/2021, within bracket new, and TS 44/2017 old, whereby the trial court had rejected the prayer of the present petitioner under Order 8, Rule 1A of the Code of Civil Procedure, read with Section 151 of the said code, for production of certain documents on which the defendants were relying their case at a belated stage. So, issue notice to the respondents, since Mr. T.R. Gogoi has appeared for respondent number 2 and 3, no formal notice need to be issued to the respondent. As against respondent number 1 and 2, 1 and 4, the petitioner shall take steps for issuance of notice on the said respondents by speed post within 3 days from the date of this order, returnable on 16th of December. List according.
Under this setup, my lord, if your lordship please, my lord, I want to place an order, my lord. In that order, I pray for an interim, because otherwise the defense witness has been, my lord. One day, only for a moment, my lord. It says that,
What order?
the Supreme Court order, recent order 2020, my lord. So where in similar case, my lord, paragraph 9, my lord. Your lordship please, my lord. Paragraph 9, my lord. It is often said that procedure is the handmaid
No,
of
we
justice.
will examine those things, whether procedure is in this case handmaid of justice.
In the landscape for different witnesses, my lord, proceed, my lord. that I
What
will-
interim you want? You want stay of the suit?
For the timing till 16, my
No.
lord, 16, my lord.
No, let the other side appear.
Then, my lord, filing petitions, my lord, that may be considered for, my lord.
That you are at liberty to file.
That-
No, nothing.
Otherwise, I will be placed on this.
You may file an application that you have approached this court, but no observation in this case.
Item 4.
This present petition has been filed against the impugn order dated 4/2/2022 passed by the Learned Court of Munshi, Rongi, Hamburg. I have enumerated in para number 9 and 10 about the status of the case, my lord.
Where is the impugn order?
Impugn order page 88, my lord.
Impugn order or decree?
Order.
Relevant portion, my lord, at page 89, second paragraph.
What is the order?
Order rejection of the petition.
Limitation, condonation of delay.
Continuation of delay part
That was allowed.
allowed.
What was rejected?
Rejected,
They wanted to
prayer
file
for-
some additional documents along with the amended written statement. That was rejected.
Read that portion. Read page 89, para 3 from para 3.
The petitioner has filed a petition under order 47 rule 1, order 18 rule 4(2) and 17, and order 8 rule 1(a)(3). It is section 151 of CPC with a purpose review, setting aside, allowing the defendant number 2 for re-examination by producing or exhibiting the documents annexed with, and also prayer for alteration of the order dated 35/2019 passed by this court. Let me first consider the prayer of the petition under order 47 rule 1 for review of the order dated 35/2019.
What was this order? 35.
35 rejection of the
By way of
Prayer.
35, 2019, my lord, the additional written statement that they had filed, that was rejected
Okay, earlier.
earlier.
Okay. There, read further.
Let me first consider the prayer of the petition under order 47 rule 1 for review of the order dated 35/2019. The petitioner submitted that defendants petitioners are neither considered nor allowed to file their additional WS and its annexure, even when they were allowed by order dated 15/2/2019 to file additional WS along with annexure. The previous engaged counsel failed to annex those documents to the WS and not exhibited to the evidence. The petitioner prayed for review, setting aside the order dated 35/2019 and allowed the defendant number 2 be re-examined by exhibiting the documents. The opposite party, by filing written objection, submitted that the defendant's petitioner in the name of additional WS inserted new plea beyond the scope of amended portion of the plain without leave of this court, and as such, the plaintiff filed an application to not accept the additional WS filed on 8/3/2019 by the defendants.
Is there any counterclaim?
No, my lord.
Okay, okay.
An application to not accept the additional WS filed on 8/3/2019 by the defendants, and the court passed the order dated 35/2019 and returned the additional WS, and as such, question of review against the said order does not arise, as there is no erroneous cause at the time of passing the said order. The opposite party further submitted that the defendants have no locus standi to file the instant petition for review of order dated 35/2019 without vacating, saying recalling the order dated 25/6/2019. My lord, in this regard, I may be permitted to explain. The opposite party in the plaintiff in the earlier suit, but in the court below, actually did not file any written objection against the petition filed by us. Without obtaining written objection filed by the plaintiff side, the learned court below directly or straightway rejected our prayer. It has been already mentioned in my petition also. For exercising the power under order 47 of the CPC the court's limit is confined to 3 title issues, and those are 3. There must be error apparent on the face of the record, or the petitioner making such petition must be able to show that he has discovered new and important matter or evidence which is after the exercise of due diligence was not within his knowledge. Also, in such cases, the petitioner must show sufficient reason that any judgment which is against the petitioner was wrong or illegal in any manner. Here in this case, the only ground taken by the review petitioner is that his previously engaged counsel mistakenly failed to annex those documents to the WS, and those have not been exhibited to the evidence on affidavit. The petitioner further stated that the petitioner was neither considered nor allowed to file their additional WS and its annexes even when they were allowed by order dated 15/2/2019 to file additional WS along with annexer. On perusal of PS 21/2027, it is seen that order dated 15/2/2019, the defendant was allowed only to file additional WS in connection to the amended plan. After thorough perusal of the amended plan and the additional written statement of the parties, it is found that the plaintiff paid for changing of DAG and patta number, and accordingly it was changed in the amended plan. Whereas in the additional WS, it is seen that the defendants have added additional facts in para number 13A of additional WS and also relied upon certain documents. It is pertinent to mention here that the documents which the defendant included in para number 3 within bracket A of the additional WS, the same was rejected by the court for production. Height order dated 25/6/2018. The order already been passed rejecting the prayer of the defendant for production of documents. The defendant, without praying for setting aside the said order dated 25/6/2018 and without taking leave of the court, has brought those facts in their additional WS. The grounds taken by the review petitioner and putting limits upon his previous engaged counsel are not sufficient reason and are issues related to the fact, and as such the issue of review being confined to law. Such ground cannot be sustainable to show that the order dated 35/2019 in PS number 21/2017 has already any kind of manifest error. Also, it is seen that the said order does not suffer from any error as apparent on the face of the record. The said order has been passed on merit after considering submission from both sides and after discussing all facts and circumstances. In order to attack the provision under Order 47 Rule 1, the mistake must be apparent on the face of the record, which means that the mistake must be self-evident and needs no such and shares at its face. The order dated 35/2019 does not suffer from any such evident error to attack the provision under Order 47 Rule 1, which is a very limited power and cannot be exercised in cases where the mistake is not self-evident. In view of the above discussion, I do not find any merit in the petition filed by the petitioner under Order 47 Rule 1, read with Section 151 of CPC, and the same is rejected. As the prayer for review of the order dated 35/2019 is rejected, prayer under Order 47 Rule 18 Rule 4(2) and 17 and Order 8 Rule 1A 3 is accordingly not taken into consideration and the same meets the same fate of rejection.
Where is the error?
Now,
Where is the error in the impugn order?
impugn order when other side has not submitted any written objection to the petition filed by the petitioner. And without taking that part, the learned court below has passed the order rejecting our.
No.
And on the other hand, your.
The court rejected your prayer only on the plea that the amended plaint was allowed only in respect of a specific, a limited issue of changing DAG number and patta number. But And to that extent, you were allowed to file written statement. But you exceeded, you added some new facts and new documents, which was not allowed. And therefore, the court rejected that.
The documents actually which were subsequently filed by the petitioners before the learned court below, they are very much essential documents because leading to the
No, but
concerned land-
additional WS was allowed only under a particular circumstances,
Hello.
because they filed amended plan, not on your any other prayer. And review application has been, what is the error in the trial court refusing to review its own order when it finds no apparent mistake therein? Why this court should exercise the power of superintendence?
Since the present petitioners, the defendants in the learned court below, they have some documents which are important because leading to the land dispute land, those documents are important. Those documents or Marcel deeds were not furnished by the earlier engaged counsel at the time of filing WS. And subsequently, that defects were tried to be eradicated by the learned counsel below, previous counsel, but that points of vital documents was rejected by the learned court below. And subsequently, I have been engaged in the learned court below. And after knowing all these things, I subsequently filed an application before the learned court below, basically on the ground that earlier counsel did some mistake. Due to the mistake of the earlier engaged counsel, a party cannot be suffered. That point was raised by me, but that particular point was not discussed by the learned court below while passed the order. On the other hand, the Honorable Supreme Court has, in different cases, mentioned that one cannot be suffered due to the negligence on the part of the earlier engaged counsel. That particular point has not been mentioned in the order passed by the learned court below. And without the documents properly submitted before the learned court below, court cannot pass any suitable order or decree or judgment. That particular point was also not considered by the learned court below. This is my humble submission before this honorable court. Without those documents, actually the defendants shall not be able to raise their or they claim their any relief regarding the suit land, in which they are already possessing. Honorable Supreme Court has also decided that if there is no possession, the party cannot claim injunction or any other rights.
Yes.
Wait, please.
Anything else?
Mali?
Any,
So my humble submission before the honorable court, the petitioners may be allowed to file, allowed to be re-examined by virtue of their documents which are already being under their custody. Otherwise, they shall be there. This is my humble submission before this.
no, what is the stage? At what stage the suit is pending?
My
My lord, the suit was pending at the stage of evidence, my lord,
Evidence of?
evidence of PW. At that stage, they had filed an application saying that, my lord, amended plaint was filed and we ought to have been given a liberty to file additional written statement. So we did not oppose to that prayer, my lord. Then they filed additional written statement. We had just changed the DAG number and Patta number, my lord. Instead of 330, we had inserted 303 and nothing more. Thereafter, they filed the additional written statement, my lord, wherein they have brought new facts, my lord. Para-wise, they had replied, my lord, bringing numerous facts, my lord. And they wanted to produce some additional documents also. Those documents, my lord, they had already filed an application under Order 8, Rule 183 in the year 2018 to produce those documents, my lord. Those documents were already rejected, my lord, at page 53. So, my lord, if they want to review an order, my lord, they ought to have reviewed the earlier order, not the subsequent order, my lord, because that order has attained finality now.
Page
53,
53.
my lord. Already they had filed an application that was rejected. By order dated 25/6/2018. My lord is what?
Yes. Same documents.
Same documents, my lord. At para 3, my lord, I'll reading from the 7th. My lord. The petitioner stated that the case is at the stage of cross of PWs and stated that defendants had taken the plea of purchasing the suit land through registered sale deed, which are found either during the time of submission.
This
which
was filed before filing additional WS.
My lord. This was filed before additional WS.
Okay.
Additional WS was filed, my lord, on in the year 2019. This is of 2018. Which are not found either during the time of submission of written statement, and on 24/4/2018, the defendants have got those missing original sale deeds and desire to submit the documents. The petitioner have stated that the deed number 683 of 61, deed number 477 of 65, deed number 3262 of 64, deed number 1702 of 75, and deed number 16147. Same documents, my lord, which are related to the suit land along with other pattas and which are claimed by the plaintiff were executed by the father of the plaintiffs in favor of the defendant parents. The petitioner further stated that the documents are necessary for fair decision. The petitioner further stated it will not prejudice the plaintiffs as the plaintiffs will get the opportunity to cross-examine the defendants regarding the authenticity of the documents.
This order was not impugned,
Not impugned. my
not
lord.
challenged
No
anymore.
challenge, no way. No revision, no appeal, nothing, my lord. So
Okay.
this has attained finality now. my lord. So now by way of my lord review application, so this cannot be allowed, my lord, because there is no error apparent on the face of the record, and this order has attained finality. That is my limited submission, my lord. And the other ground that they have taken in the review that the council could not produce, my lord. So this order will stand, my lord, and there is another judgment of the Honorable Patna High Court, my lord, which says that conducting counsel, my lord, who has failed to advance argument or produce any document, that will not be a subject of ground for review, my lord. That, my lord, I can please. Madras, please. AI 1962 Madras, para 8, my lord. It is next contended that a particular counsel who appeared for the appellant before us was instructed by him to his senior counsel at the trial to raise a point based on principle embodied in section 88 of the Indian Trust Act. But at the hearing of the appeal, he failed to argue the point, and this misconduct, that is how this one described on the part of the counsel arguing the appeal, was a sufficient ground for review. In support of his contention, reference was made to a number of decided cases. I think it will be wholly unnecessary to refer any of them, as I am of the opinion this is of those cases proceeded under particular facts and laid down no principle applicable to the instant case. Assuming that the counsel who argued the appeal before us had specific instruction from his client to argue a certain point, and he failed to argue the point designedly or by inadvertence, I do not think that in itself, without anything more, would be enough to warrant a review of the judgment. Similar also, my lord, here they are saying that the counsel could not produce those documents, my lord. If the council failed to produce those documents, my lord, then they ought to have challenged the order dated 25/6/2018. But that would not ipso facto, my lord, be a ground for review.
Okay. Heard.
My lord, I may be permitted to produce two judgments.
Yes.
Order 9, Rule 18/17 of the court enables the court at any stage of a suit to recall any witness who
No,
has
we are
given a-
in this, Mr. What is the name?
MS Ali, my lord.
Mr. Ali, we are looking at the correctness of the review order which is under impugn, which has been impugned in this case. Why court why the order under challenge is right or wrong. So order under challenge is an order passed by the trial court under order 47, review order. So where the court erred in passing that order, that is only under challenge in this case.
Honorable Court may passes favorable order, if this Honorable Court may deem fit and proper.
No,
My humble submission before this Honorable Court, if party can produce any documents at any stage before passing judgment.
you give your judgment. Heard Mr. M.S. Ali, learned counsel for the petitioner. Also heard Mr.
A Iqbal.
A. Iqbal, learned counsel for the respondent. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 2/2/2022 passed by the Court of London, Munsif, Ramia, Kamrup in miscellaneous case number 25/2019, whereby the London Trial Court declined to review its order dated. Which order is declined to review? Order dated
35/2019.
35/2019, whereby the whereby the
Additional WS and the related documents were reviewed.
prayer for accepting the additional WS and additional documents filed therewith was rejected by the trial court. Learned counsel for the petitioner has submitted that the petitioners who are the defendants in title suit number 21/2017, which is pending before the Court of Learned Munsif Ramia, were allowed to file additional written statement after the plaintiffs. How many plaintiffs are there? After the plaintiffs were allowed to file an amended plaint in the said suit. He, however, submits that the where is the impugn order?
Page 88, hello? Page 88.
Where is the order dated 35/2019?
That they have not annexed, my lord. I have a copy.
That is under review. That was under review
Yes,
before.
sir. That order has not been.
That. And amended plaint in the said so. Here submits that on 39/35/2019, the
Para 6 onwards. The discussion is in para 6.
the trial court declined to accept the additional written statement furnished by the defendant on the ground that it introduced new story which was beyond the changes brought in the plaint by filing of the amended plaint. And where is the order 8?
Page 53, my lord. Order dated 25/6 April.
Learned counsel for the petitioner has submitted that the documents and the plea taken by the petitioner has submitted that the plea taken by the petitioners in their additional written statement and the documents which were filed along with it are very much necessary for the decision of for the just decision of the real dispute between the parties. He submits that the earlier engaged counsel was instructed to take those pleas and to submit those documents. However, he failed to do so. And therefore, a new set of lawyers have filed that.
Subsequently, I was filed, I was engaged in the line could be.
Stop. He further submits that the said documents would be necessary. The ends of the justice would be served only if the petitioners, as defendants, are allowed to if the documents furnished by the petitioners along with their additional written statements are accepted by the court. Stop. He therefore submits that the impugn order is liable to be interfered with. In support of his submission, he further submits that for arriving at just decision of the court, a civil court is empowered to accept documents at any stage of the suit. He also submits that a party should not be made to suffer on account of default on the part of the engaged counsel. Stop. On the other hand, learned counsel for the respondents has submitted that there is no infirmity in the order impugned in this case. He submits that the present respondents as plaintiffs were allowed to amend the plaint only to the limited extent of mentioning correct dag number,
Again, patta number.
dag and patta number in the case, in the schedule of their plaint. And only to that extent, the present petitioners, comma, as respondents, comma, were allowed to file additional written statement. However, they went while filing the additional written statement. The present petitioners made out a new story and took new defense, which were not pleaded in their original written statement. He further submitted that the petitioners also submitted the documents which were earlier not allowed to be submitted at a belated state by order dated 25/6/2018. He also submits that same documents which were tried to be introduced by the petitioners, comma, as defendants in the suit by filing an application under Order 8 Rule 1A by petition number 550/2018 was rejected by the trial court on 25/6/2018, and the said order was not put to any kind of challenge by the petitioners. However, they again tried to introduce the said documents along with the additional written statement, and as such, same was rightly rejected by the trial court. He further submits that there is no apparent error. There is no error apparent on the face of the order which was put under review, and accordingly the trial court, by passing the impugn order, has correctly declined to review the order dated
35, 2000.
35, 2019 stuff. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. It appears that by the impugn order, the trial court has declined to review its order dated 35, 2019, in as much as it found that there was no error apparent in the said order. It also appears that the trial court found no illegality in the order which was put under review. Neither any new facts were produced by the review petitioner before the trial court. It further appears that the plaintiffs in the said case were allowed to amend their plaint only to the limited extent of mentioning the correct DAG number, and thereby which para was included?
Paragraph number 20 and 21. We have made the correction through by way of hand, madam. No separate.
Alika lastly. Mentioning the DAG number and made no other altercation, no other changes in the original plaint. And to that extent only, the present petitioners as defendants were allowed to file the additional written statement. However, it appears that in their additional written statement, the present petitioners added certain new facts in paragraph number 13 within bracket A of the additional WS and relied upon sale deeds and revenue receipts which were earlier denied by the trial court to be submitted by the defendants by order dated 15/2019. This court therefore finds that stop. I will dictate the remaining portion in chamber. The revision petition is dismissed.
Deeply obliged.
Oh, PP9. We'll take it in the second half, criminal matters. All criminal matters at 2.
May it be the lordship. I am for the father lordship seeking custody of the minor child. They are representing mother. At
Yes,
the-
well, we are appearing for all respondents, ma'am. Mother and,
Mother, grandfather, grandmother.
yes,
The child is with,
Grandfather, grandmother.
ma'am, as
Mm.
per cause list recorded also not received. As, as
No.
called for by.
how old is child?
Lordship, now he crossed 7 years. At the time of filing of the petition, 5 years, lordship. So as per Mohammedan law, after 7 years, lordship, mother has no right for custody, lordship. And in this case, lordship, when she remarries to some other person, even before 7 years, father can serve for custody, lordship. Lordship can dispose it up at admission hearing if my learned friend is ready, lordship.
Records also necessary, ma'am. Records are not received.
For
as called
records,
for.
lordship, appeal has to be admitted, then it will go to final hearing, lordship, it will delay the. matter.
Is there any hope of amicable settlement between the parties?
She in the meantime, wife again remarried and husband also he remarried, lordship.
Oh,
Both parties are separated by a mutual divorce, lordship. Only the dispute is that the child is with the grandparents and father wants to give him better education.
maternal grandparents.
Yes, lordship.
Maternal grandparents, yes.
As per Mohammedan law, grandfather is the custodian of the male child, lordship, natural guardian.
No,
As per
as
law,
because,
father is entitled, lordship.
Now what is to be done? This cannot be disposed of. Can it be disposed of today? No.
no, my lord.
Lordship on a hearing date. Because the child.
We
has
have to
al-
file objection also. Some instruction also had to be received. So
They got enough
Oh,
time,
after 4
lordship.
weeks maybe,
Notice was issued on 14/8/2024.
and a record also not received as called for by this honorable court.
Okay, let record come.
Lordship.
Heard Miss R. Chaudhary, learned counsel for the appellant. Also heard Mr.
Here, my lord.
A. Rahman, learned counsel for all the respondents. It appears that records were called for.
At 14/8/2024, lordship.
It appears that the scanned copy of the trial court records which were called for have not been received
From the principal judge, family court.
from the Court of Learned Principal Judge Family Court Dhubri. Issue reminder for the same. Stop. Learned. You want to file written objection?
Yes, my lord.
Learned counsel for the respondents. Praise for allowing the respondents to file written objection. Same is allowed. We'll admit this appeal.
Then lordship, it will come in the hearing column and 2024 matter, it will take time, lordship. May I pray your lordship to, lordship, dispose of this matter at admission hearing,
Now we'll give fixed day for hearing.
lordship. Then your
Mm.
lordship.
The appeal is admitted. Considering the nature of the issue involved in this appeal, let this matter be listed for final hearing on a fixed date. That is on. How much time will you take?
4 weeks time.
16 December or first week of January.
16 December, Lordship, and registry may be directed to bring the LCR, Lordship,
Yes.
positively before that date.
16th of December. Let registry direction this Deluni register to take steps for requisitioning the scan copy before this end date. List accordingly.
মাত্র।
May it please your worship. Well, this CRP IO is filed under Article 227, read with section 151 of the CPC Milord against one order, order passed by the learned additional district judge number 2, Nagaon Milord, which is at page 20, where one interim maintenance was granted in favor of that petitioner, and against this, against that petitioner in the matrimonial suit, Milord, she filed one petition under section 24 of the Hindu Marriage Act, which is at page 29, and the impugned order is at page 20. Here, the learned trial court below, Milord, directed to pay an interim, Milord, maintenance allowance of rupees 8,000 per month to the present respondent, Milord. The impugned order starts at page 20 and the relevant portion, Milord, page 26, para 12. Para 12.
Yes.
Here, Milord, one fact is this, Milord, this petitioner has suppressed one thing. This petitioner, the present petitioner, has been paying one interim maintenance in a case filed by the respondent, Milord, in another, Milord, 125 CRPC matter, where this petitioner has been paying rupees 8,000 per month to the present respondent, Milord. That fact has not been, Milord, stated by the petitioner, but the present petitioner has stated in his written objection that the petitioner has been paying 8,000 per month in
So that was taken into
consideration. But, Milord, one thing has not been taken into consideration. The petition, which is I have annexed at page 29, Milord, she has filed without, Milord, disclosing the assets and liabilities as, Milord, required by as per the direction of the Honorable Apex Court, Milord, in Rajneesh versus Neha. And secondly, Milord, this petitioner has, Milord, stated in his written statement that, Milord, written objection, Milord, that he has liability 3,50,000 and 15 lakhs. He has given his position of assets and liabilities in his written objection, Milord.
Divorce suit is pending.
Pending, and now it is for on 7/1/2026 for cross-examination. Cross-examination of the PW.
So your main plea is that your assets and liability, affidavit on assets and liabilities has not been submitted, and
By the petitioner.
you don't have capacity to pay.
Yes. She has not submitted as required as per the direction of the Honorable Apex Court in Neha, Rajneesh versus Neha, where it is Honorable Supreme Court has shall submit, and it was annexed, Milord, as
And you have submitted.
yes, Milord. So that part, Milord,
What is your plea that whether she's engaged somewhere, she's working.
Is my lord doing some business, and my lord, fact is this, my lord. She is already living with another person. And the wife of that person has lodged one FIR, I have an ex. And that wife has also filed one divorce case also against that, my lord, third party. This is also going on, my lord. Now, this petition is all constable, my lord. This interim maintenance is too much. So if your lordship kindly remand this matter for fresh examination.
How much you can pay?
I have been paying me 8,000 or at best 10,000. I have not taken any instruction, but from my side, I think, my lord, that
No,
part.
no. Why to remand? Where the court has heard. Court has heard only in as much as that the petitioner failed to submit her.
Assets and liabilities.
So what was your plea? How much she is earning? According, was there any?
She is earning means, my lord, what?
No, no, my query is, was there any plea in your objection that she is not unemployed, she is earning something?
Yes, my lord,
Whether that plea,
yes, objection is at page 31.
yes. You have stated about your earning only. Yes. You have not taken that plea that she is earning something. Then assets and liabilities becomes irrelevant. Though there is a Supreme Court direction, but suppose you don't take a plea, then how it would have helped you? Yes.
My lord, lordship, in that written objection, they have not taken the plea. And it is not the case that only I have failed to submit the assets and liabilities. If your lordships come to page 21, the impugned judgment, lordship, paragraph 4, all the both the parties, lordship, they have failed to submit assets and liabilities. Paragraph 4, lordship, last paragraph. Lordship, the section 24.
But you were getting 8,000.
Yes, in the that 125 case, lordship.
Yes, that
But
you have.
that is reflected in the judgment, lordship. And what I am on, lordship, the very object of the section 24, lordship. Allegations, counter allegations are definitely there, but what lordship section 24 says, lordship, may I read, lordship?
Yes.
Yes. Section 24. Where in any proceeding under this act, it appears to the court that either the wife or the husband, as the case may be, has no independent income sufficient for her or his support and the necessary expenses of the proceeding, it may
on the application of the wife or the husband, order the respondent to pay to the petitioner the expenses of the proceeding and monthly during the proceeding such sum as having regard to the petitioner's own income and the income of the respondent, it may seem to the court to be reasonable. The very word appears, it appears to the court, Lordship. So Lordship, that latitude is given to the court. It appears that available materials, whatever available on record, on the basis of that, the learned trial court has passed the order. And Lordship has said about that 8,000 maintenance, Lordship.
But in the detailed objection, my lord.
Lordship, in page 25, Lordship.
Yes.
Yes, page 25, Lordship. In the middle part, Lordship, the respondent husband has given a list of expenses. Lordship has got it.
Yes.
The respondent husband has given a list of his expenses in paragraph 25 of his written statement filed in the main case, where he indicated his expenses of electricity charges as so-and-so, medical expenses so-and-so, conveyance as so-and-so, food as so-and-so, and miscellaneous expenses as so-and-so, totaling 10,800 per month, amongst other payments for his home and personal loan. If he alone needs 10,800 personnel expenses per month, it cannot be said that 8,000 per month as interim maintenance granted in the aforementioned MRKs is sufficient for 3 people at the rate of 2,666 point something, Lordship. Because the wife is having two minor daughters. That 8,000 is paid not only to the solely to the wife. That is also given to that minor daughters also. So that reason has also been given here, Lordship.
Yes, anything.
Regarding the liabilities, my lord, in paragraph page 32, my lord, is stated the petitioner with a view to harass financially and mentally, he has filed this petition seeking interim maintenance. The opposite party is a constable and he is earning a meager amount, the details of which already submitted in the main petition in proceeding 44/2021. The opposite has other liabilities. He had taken a loan of rupees 15 lakhs to construct a house in the year 2015 and another personal loan of rupees 3,50,000. The opposite party is paying monthly installment 15,861 for home loan and rupees 6,591 for personal loan. Apart from monthly installment, he has already these things are he has stated.
And Lordship,
But in the petition filed by the petitioner, nothing has been said. Even she has suppressed the earlier payment regarding she has been receiving rupees 8,000. This minor daughter, one is at reading at class 1 at that time last year, now class 2 maybe, and one is at 8. And this petitioner, my lord, submit in his this petition, my lord, she is earning, she is giving one soft, my lord.
Lordship, page 79 is a written statement filed by the petitioner in the main matrimonial case, Lordship. It starts from page 79 and relevant portion is at page 87, paragraph 25, Lordship, where all he has given the expenses and all. But here we cannot, it is seen from the record that he has submitted the assets and liabilities. He has given some third.
Page 87, para.
Page 87, paragraph 25. It starts from 25. Is a written statement of the husband.
No, what is your submission?
The Lordship, I am from this paragraph, I am saying that here, Lordship, they have in the written statement only, they have stated their expenses and all. No separate assets and liabilities is filed by the husband, Lordship.
So definitely lordship, the order 18/3/2024. Honorable Court has passed that order on the basis of the material available on records. So there is no infirmity in that order, and that 8,000 per pendental life is for that minor, including that two minor daughters also, lordship. It is not that wife will get. And this order was passed on 18/3/2024, and it was given from the direction was given to pay from the date of filing 37/2022. And now we are on the November 2025. Not a single penny has been given regarding this order. It's almost 3,26,000 something, lordship.
Okay, heard Mr. R. Goswami.
Just one joint petition they filed before the Judicial Magistrate First Class at page 56, my lord. In MR case number 48/2021, they have said most especially the petitioner first party and the respondent second party beg to submit that the above noted case, the second party has agreed to give interim maintenance of ₹6,000 only to the petitioner first party and two minor daughters. That the petitioner has also agreed to receive ₹6,000 as interim maintenance amount from the respondent. As such, joint petition has been filed by both the parties. Now she has agreed to receive 6,000. Again, thereafter filed this petition praying for 10,000 and 20,000, my lord.
Lordship, that was prior to the decision of the
Divorce.
maintenance case, that mutual. And lordship may come to page 37 now, lordship. The judgment of that maintenance case, lordship. Last paragraph, lordship. Page 37, lordship. Last paragraph. It is submitted by the counsel for the first party that although the second party has agreed to pay the first party maintenance of 6,000 monthly, the second party has neglected to do so. He has not paid. Even I have asked the conducting counsel there also, although it was mutually agreed, but he has not paid. That's why Honorable Court has passed that order in the maintenance case, lordship. So that plea cannot be taken. We are earlier agreed to pay in the monthly maintenance of ₹6,000. But ultimately, lordship, that order is there, maintenance case. That order not has been challenged by the petitioner, lordship. And the section 24 clearly says, appears to the court.
Okay. Heard
Another
Mr.
thing, just 1 point, my lord, for your my satisfaction, my lord. Page 61 is the photograph with that, my lord, person, my lord, third party. This respondent and the third party, my lord. And the FIR is at page, my lord, 58. He's living adultery, my lord. Despite that,
Lordship,
if the petitioner has to pay
No,
60,000.
this photograph is not a proof of adultery.
Yes.
Otherwise, you can file 127 application before the
120.
heard Mr. R.
Matter of
Goswami,
proof, lordship.
learned counsel for the petitioner. Also heard Mr. What is your name?
SR Burma.
S.R. Burwa, learned counsel for the respondent. This application under section under Article 227 of the BNSS has been filed.
No, my lord.
Sorry, under Article 227
Of the question.
of the Constitution of
Read
India,
in section 1.
read with section 151 of the CPC, has been filed by the petitioner, namely Sanjeev Hazarika, impugning the order dated 18/3/2024 passed by the Court of London. Additional District Judge number 2, Nagaon, in Ms. J case number 27/2022 in connection with matrimonial within bracket divorce case number 44/2021, whereby on an application under section 24 of the Hindu Marriage Act 1955, the petitioner was directed to pay an interim maintenance allowance of rupees 8,000 in total to the respondent and her children and her minor children. As well as an amount of rupees 6,000 per month towards the expenses of the proceedings. Learned counsel for the petitioner has submitted that the present petitioner has instituted a divorce suit seeking divorce from the respondent before the court of London.
This was
Additional,
filed by, the divorce
Filed by
case was
me.
filed by.
By the
respondent.
wife.
okay,
And expenses 600, not 6,000.
filed by the wife.
Wife.
Against the husband. I have filed one restitution petition.
Okay,
The husband has filed one restitution petition.
has submitted that the present respondent, who is the wife of the present petitioner, has instituted a divorce case seeking divorce from the present petitioner before the Court of London Additional Session Judge, Additional District Judge number 2, Nagaon, which was registered as divorce case number 44/2021. Your restitution of conjugal right is pending.
Yes.
He further submits
But it
that
is not
the-
reflected in the pleadings, I guess.
no, that is your submission.
Yes, yes.
He further submits that the present petitioner on the other hand has filed an application under section 9 of the Hindu Marriage Act for restitution of the conjugal rights. Say, you do have the case number? Stop. He further submits that in the said divorce case, the respondent had filed an application under section 24 of the Hindu Marriage Act seeking pendente light maintenance and expenses of the proceedings from the present petitioner. And by the impugn order, the aforementioned maintenance allowance and expenses of proceeding was directed to be paid by the present petitioner. He submits that the trial court has learned counsel for the petitioner submits that the trial court had failed to take into consideration while granting the aforesaid maintenance allowance and aforesaid pendente light maintenance and expenses of the proceeding, in as much as the respondent, while filing the application under section 24 of the Hindu Marriage Act, had suppressed the fact that in an earlier proceeding under section 125 of CRPC, which was registered as Ms. J case number 48/ no, which was registered as the 125 has been
Yes, yes.
disposed of.
Yes, my lord.
Disposed of
At page 42, yes. Page 42,
48.
42.
Ms. J case number
It is, my lord.
MR case number.
MR case
48.
number 48/2021.
MR case number 48/2021,
Under section 125 CRPC.
whereby the petitioner was earlier directed to pay an amount of rupees 8,000 per month to the respondent and her minor children, minor daughters. Stop. He further submits that the trial court also failed to take into consideration the fact that the petitioner, while submitting the application under section 24 of the Hindu Marriage Act, failed to submit any affidavit of her assets and liabilities in support of her claim. He also submitted that the petitioner, in his written objection to the application under section 24 of the Hindu Marriage Act, as well as in the written statement filed in the main divorce suit, has specifically stated about his liabilities, including repayments of home loans and other liabilities. Your liability extends to how much?
That is at page below in the written statement. Yes.
88.
Yes. It's 58.
Which amounts to total of rupees. How much salary you get?
I have not stated anywhere.
Which amount to total of rupees 38,252 per month. He further submits that in the meanwhile, the trial court also failed to, he further submits that the trial court also failed to take into consideration the fact that after separating from the present petitioner, the respondent is staying with another person. He therefore submits that he therefore submits that the impugn order is therefore liable to be interfered with, as the trial court failed to take into consideration above aspect. On the other hand, learned counsel for the respondent has vehemently opposed the prayer of the petitioner on the ground that the trial court has passed the impugn order after taking into consideration all the aspects, and no infirmity is there in the impugn order warranting any interference by this court. He submits that though the petitioner has not submitted any affidavit of assets and liabilities, however, the fact that the petitioner and her minor children were directed to be paid monthly maintenance allowance of rupees 8,000 per month in MR case number 48/2021, was taken into consideration by the trial court while allowing pendente light maintenance and expenses of the court. He submits that while considering an application under Section 24 of the Hindu Marriage Act, the court has primarily to look into the fact as to whether the petitioner who is applying for such a pendente light maintenance and expenses of the proceeding has no independent income sufficient for her or his support. He submits that same has been taken into consideration by the trial court. He further submits that though the trial court has passed the impugn order in the, you have received maintenance amount.
Lordship,
One-
that part, Lordship, I filed that section 24 application on.
You have not received a single penny under 24,
Yeah, in this case, Lord.
but in
In this case also some pending is there. They have filed one execution case.
impugn order on 18/3/2024, directing the petitioner to pay the pendente light maintenance as well as expenses of the proceedings within, with effect from 30/7/2022. However, till date, not even a single penny has been paid by the petitioner on that count.
Well, regarding the salary, I have stated in para 7, page 11, how much he is earning. The third line, para 7, page 11 of this petition below. It is 50,587 per month.
উপরত petitioner submission of the human. Okay. Somewhere we have to include it. Learned counsel for the petitioner further submits that against the aforesaid liability is to be incurred by the petitioner, he draws a net place of 50,587 only. Stop. You have any other submission?
Lordship, regarding that separation of that, getting the interim order in the maintenance case, Lordship, the application under section 24 was passed prior to that interim order. Because yes, because Lordship, that interim order in the MR case was passed on 1/2/2023.
Learned counsel for the petition, learned counsel for the respondent has further submitted that as the application under section 24 of the Hindu Marriage Act 1955 was filed by the respondent prior to final order in MR case number 48/2021. The
And Lordship,
the petitioner, the respondent could not mention about the direction given by the judicial magistrate first class Nagaon regarding payment of rupees 8,000 to the respondent under section 125 of CRPC.
and he is having agriculture income also that is reflected in page 21 of the judgment. Lordship. Page 21 of the writ petition. Lordship. Monthly salary as well as agricultural income.
He where is that agricultural income?
Page 21 of the this petition, Lordship.
Where, which?
First paragraph, Lordship. Fourth line, Lordship. The respondent has.
No, that is your claim. He has not admitted.
Lordship.
Learned counsel for the respondent has further submitted that the respondent also had taken the plea in her application under section 24 of Hindu Marriage Act that the petitioner, in addition to the monthly salary which he gets as a constable of Assam Police, has income from agriculture also. Stop. I have considered the submissions made by learned counsel for both sides. Within a week, next week, reserving the operative part. Both sides then have gone through the materials available on records. Reserve corridor. I'm reserving the judge.
Lordship. Obliged.
Obliged to you.
CB.
But,
The additional affidavit I sent. Yeah. We will fix it on some other day.
Or regarding our.
What is the issue?
Issue is,
I have revoked section 301 of the Indian Succession Act for removal of the executor from the will.
no succession has been issued till today.
Removal of the executor.
That was refused, that was declined by the trial. That was declined by the trial court.
No. He has not filed a probate case yet, my lord.
Okay.
So because of his conduct, my lord, so I have before this honorable court for removal of his executorship, my lord. And he has admitted, my lord, why in his affidavit, my lord, that
No, on the last occasion, there was an,
no, that was, my lord, sorry to say, my lord, there is no kind of any discussions going on, my lord. I am instructed by my client, nothing is happening, my lord.
He was
It was
approached,
absolutely a false statement, my lord.
no, he was approached by the tenants those who were paying.
No, no.
There, but he being our master, or we are all the owner of the land, and being the landlord, there was a proposal was given. Why do you fight for it? Take it.
No, no,
you
I
have to
was not
settle the matter.
given any
And now,
proposal.
my lord, we are ready to file this probate, my lord. It is also time barred, my lord. They have not raised it earlier.
So far as this,
Without the succession certificate, how they can come, my lord? No succession certificate applied.
What is 301?
PG1 Miller, it says removal of executor or administrator and provisions for successor.
Please read. Where this application has to be filed? High Court?
High Court. High Court. May I read, Miller?
Read that portion where,
The High Court may,
okay, okay.
on application
okay,
made to.
okay. Then let the additional affidavit come on record. Heard Mr. R. Chakravarti, learned counsel for the appellant. Also heard Mr. S.C. Vishwas, learned counsel for respondent number 1, 2, and 3. Though on last occasion, it was reflected in the order that there was that this court was informed by the learned counsel for the respondent that there was a possibility of amicable settlement, as some well-wishers have come forward to settle the matter amicably between the parties who are brothers in relationship. However, learned counsel for the petitioner submits that no such step has been taken and there is no possibility of any amicable settlement in this case. Stop. Learned counsel for the respondent has submitted that the respondent has filed an additional affidavit in this case, as same has not been placed on record, and therefore requests the same to be brought on record. The registry is directed to place the additional affidavit filed by,
Affidavit, my lord.
affidavit filed by the respondent to place on record on the next date fixed. When we can fix?
Any day as per your lordship convenient. My friend, when
Next week.
Is the
Choose next Wednesday, any date on next
which? All right.
week. List this matter on next week, next Wednesday, 26th of November.
All right.
Item 8.
My lord, this is an appeal under section 37 of Arbitration and Conciliation Act 1996 against the improved order and judgment passed by the learned court dated 9/9/2025. And your lordship may kindly come to page 58.
Just
Here, my lord, on 11/11/2022, the case of the respondent challenged the arbitral award under section 34 of the Arbitration and Conciliation Act. It was dismissed for default. So therefore, the respondent filed an application for restoration of the case to the file at page 49, my lord. And this petition is registered, my lord, petition number 2773 of 2022. Now your lordship may kindly come to last page, my lord. Some relevant orders are annexed with this appeal. Page 66, my lord.
Yes.
On 16/5/2025, lordship. The order is there, both sides are represented, peruse the record, fix 18/7/2025 for hearing on petition number so and so. This is about restoration petition. Next date, my lord, 18/7/2025. Both sides represented, heard the petitioner, learned counsel, fix so and so for hearing on of opposite party. Then last order, 13/8/2025. Both sides represented. OP did not turn up when the matter was fixed, taken up, fixed so and so for order. On 9/9/2025 for order, OP is at liberty to conduct the hearing on the date of fix for order. So the order, the date was fixed for order on the petition of restoration of the case, my lord. But the learned court below, instead of filing any appropriate order for restoring the case to the file, finally dispose of the main case, 37, section 34 petition on merit without hearing to the appellant, my lord, at page 21, my lord. Unless and until the case is restored to file, there is no case.
Where is
before
the
the
impugned order? Page?
Page 21, my lord. Page 21 and enclosure 1.
But after hearing both the sides,
Both the side on the restoration petition, not on the 34 petition, main petition. So unless and until appropriate order is part for restoring the case to the file, how the section 34 petition, main petition can be taken up, and that too on merit. So this is none as in the eye of law, when there is no case before the learned court below.
will issue notice.
Yes, my lord.
Lord, Mr. R. Hussain, learned counsel for the appellant. This appeal under section 37 of the Arbitration and Conciliation Act 1996, read with section 10 of the Commercial Courts Act 2015, has been filed by the appellant impugning the judgment and order dated 9/9/2025. But the court heard both of you.
Both of you on the petition for restoration of the case, 2773, not on 37.
On merit, it was not heard.
No,
Yes, Mr.
the
Gopal.
copy was not given to us.
For the order reflected in page 22, Lordship. Both parties are heartless. Both parties are
No,
present.
that is his submission that heard on restoration petition.
Yes.
Otherwise, it's reflected from the final order. See, it was hard and merit.
No, disposed of on merit.
Lordship, hard and disposed on merit. Merit also, Lordship, as per the statutory prescription, Lordship. If the provision is not mentioned as GCC, Lordship, then
Yeah, the other side is only Union of India.
Lordship, I represent. If when the provision is not in the GCC, Lordship, the arbitrator cannot travel beyond the Lordship terms and conditions of the GCC, Lordship. And Honorable Learned trial court has lordship rightly rejected, rightly allowed the lordship. The petition's lordship.
No, but without restoring the,
That part reflected in the TCR, otherwise lordship, both sides are hard lordship on that particular day. Even lordship.
Hard
some
on
of
the
the dated
restoration
lordship-
petition. There must be an appropriate order for restoring the case to the file. Then the matter will come up for hearing.
no, whether the judgment reflects that you were heard on merits.
Judgment it shows, but the matter was heard on for the restoration of the case.
No, it may be fixed for restoration, hearing on restoration application. But
On
on
the
that
same
day, if the court was hearing the question, matter on merits, it was your duty to point out that it
I
is
was not there on that day. The respondent
Some-
was there.
some counsel, both parties were heard.
But here, their opposite party is at liberty to conduct hearing on that day fixed for order.
No, no.
I did not, I filed the Hazira, but I did not appear.
My lord, may kindly page 23 lordship. Page 23 lordship. On that particular day, lordship, the hearing was conducted final hearing was conducted and the counsels were present from lordship on the petitioner side so and so and learned counsel appearing for opposite party so and so lordship.
Hazira was
It
there.
is it is in their presence lordship that matter was finally heard lordship. Even page 22 itself reflected that lordship the matter came up for final consideration on so and so lordship. It is not a case that lordship.
Okay,
they are not-
let us peruse the records.
Lordship.
And your lordship may kindly see this page 23, my learned brother is pointing out. Learned advocate appearing for the petitioner Bimal Sharma. He is no more advocate. He is the judge of this foreigner tribunal. So other advocate was appearing on that day for the railway side. And for my side, my name is there. My junior name is there. I did not appear, though Hazira was filed.
Okay. Can before that, also Mr. K. Gogoi, Learned Standing Central Government Council. Learned Central Government Council. This appeal impugning the judgment and order dated 9/9/2025 passed in Miss Arbitration case number 104/2024 by the Court of Learned Civil Justice Senior Division, number 1 Kamrup Metro in Guwahati. The main contention of the Learned Counsel for the appellant in this case is that though the appeal was disposed of in merit, it was heard without main contention of the main contention of the Learned Counsel for the petitioner is that the misarbitration case number 22/15 was dismissed for default on 11/11/2022. And thereafter, the misarbitration case number 104/24 was filed by the present appellant for restoration of the arbitration case number 22/2015.
It was filed by the respondent, not by the appellant. The representative.
Restoration case was filed by the
Respondent.
respondent. Arbitration case was filed by the present respondent. Thereafter, the present respondent filed an application under Order 9 Rule 4 for restoring the misarbitration case under misarbitration case number 22/2015. The Order 9 Rule 4 application was registered as misarbitration case number 104/2020.
Petition number 2773.
Registered as petition number
2773.
2773/2022. He submits that, however, without passing any order for restoration of the misarbitration case number 22/2015, by the impugned judgment, the trial court disposed of the misarbitration case number, said misarbitration case on merit. He further submits that on the said date of hearing, the counsel for the present petitioner, present appellant, had only filed Ajira. However, they were not present when the matter was heard. Stop. On the other hand, learned Central Government Council submits that on perusal of the impugned order itself, it appears that impugned judgment itself, it appears that the matter was finally heard after, finally disposed of after hearing learned counsel for both the sides. So, for appreciating the contentions raised by learned counsel for the appellant, the records of aforesaid cases, namely misarbitration case number 104/2024 new / misarbitration case number 22/2015 old would be necessary. Hence, all for the records from the trial court. Since Mr. Gogoi, learned Central Government Council, has already appeared for the respondent, no formal steps need to be taken for issuance of notice. List accordingly after 4 weeks. After 4 weeks.
Doesn't indicate extra copy.
Hmm?
Extra copy.
The appellant is directed to furnish the extra copies of the memo of appeal along with. Yes.
But today 86 days behind the farmer. Page number. Lordship. 13 is the one, 3 is the FIR.
Under section,
My lord, 135105 of DNS, Redwood, section 21(1) Mines and Minerals Development Regulation Act.
Earlier rejected by your lordship at
No,
page
earlier-
25.
where is the rejection
My
on,
lord,
Page 25.
and where is the order of allowing other?
my lord, page 21, my lord. Operative part lordship would see page 23, my lord. Paragraph 10.
21 is your rejection order, or
No, 23 is the order by which the co-accused was granted bail, my lord. And my rejection, it starts from my lord, page 25, lordship.
yes,
Yes. my lord,
87 days.
to the 87, only on the ground of length of detention.
Third,
certainly.
Mr. J. Laskar, learned counsel for the petitioner. Also, heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Jamal Ali alias Sona, who has been detained behind the bars since 23/8/2025 for last 83 days in connection with Umrangshu PS case number 2/2025 under section 105/3 within bracket 5 of BNSS 2023, read with section 22 within bracket 1 of the Mines and Minerals within bracket Development and Regulation Act 1957. The gist of accusation, quote para 3 from page 26. Learned counsel for the petitioner has submitted that on an earlier occasion, this petitioner approached before this court, seeking bail. However, by order dated 25/9/2025, passed in bail application number 2936/2020. His prayer for grant of bail was rejected on finding sufficient materials against him. Learned counsel for the petitioner has submitted that in the meanwhile, all other co-accused have already been released on bail. And the petitioner, who was only acting as senior manager, who was only acting as manager and who looked after financial matters, has been languishing behind the bars since last 83 days.
60.
Huh?
86.
86 days.
Yes, 86.
I got the 86 days. He submits that considering the length of detention, his further custodial interrogation may not be necessary, as the investigation might have progressed sufficiently by now, and therefore he prays for allowing the petitioner to go on bail. On the other hand, an additional public prosecutor has produced the case diary of Umrangshu PS case number 2/2025 and has submitted that there are sufficient incriminating materials against the petitioner in the case diary. He, however, fairly submits that in the meanwhile, the investigation has fairly progressed. So, I have considered the submissions made by learned counsel for both sides and have gone through the case diary. Considering the period of detention undergone by the petitioner, as well as progress made in the investigation, this court is of considered opinion that if the petitioner cooperates in the investigation, his further custodial detention may not be necessary for fair completion of the investigation of the case. Stop. In view of above, the petitioner, namely Jamal Ali alias Sona, is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Dima Hassau with following conditions. Condition number 1 and 2. Send back the case diary. This bail application is accordingly discussed.
Lordship, one thing, 21(1) of the mine and mineral company, Lordship mentioned 22(1).
21(1). Mining Act or Section 21. Okay.
Of like.
Kindly go to petition, criminal petition Lordship first.
Why contempt case is before this?
Lordship, I will. Firstly, one thing is there, Lordship.
Why this matter has listed before this court?
Lordship, because the thing is that it should be actually before the Honorable Justice of Ukon Lordship. Because here the case is that Lordship on 30/8/2022, additional session judge has allowed the Zimma. Before that, additional CGM and CGM has rejected the Zimma petition of the Ereka Nath Lordship. But on 30/8/2022, Zimma has been given on bank guarantee, providing.
Okay, I am allowing before the directing the registry to list this before appropriate bench. You are appearing for? In criminal in both the cases, list this matter before appropriate bench. That is it.
Stay is given by Honorable Justice Susmita Fukan.
Yes, no order has to. List this matter before appropriate bench.
Number 35.
itu murtad की वजह से. Why this is listed before this?
Because it is earlier on this order, Lord. It is a correction, Lordship, modification. In page 10, Lord.
What correction?
Yes, Lordship. Yes. Gosaigaon PS case number is 506/2021, but it should be Lordship in paragraph. Lordship in paragraph 2. Lordship, no, it is not that. Lordship, page number. Lordship in paragraph 4.
What should be the correct?
It should be instead of Gosaigaon PS case 506/2021, Lordship. Mentioned in the order as PS Gosaigaon PS case number 506/2025 is there, but it should be 2021.
In para?
Para 4, Lordship.
Okay.
Page 6. Lordship, got it, Lordship.
Nalagi. None appears for the petitioner on call. Heard Mr. K.K. Das, learned counsel for learned additional public prosecutor. This interlocutory application has been filed by the petitioner for rectification of the clerical mistake in mentioning the police station case number in the order dated 5/9/2025 in bail application number 2663/2025, whereby the petitioner was allowed to approach the trial court after examination of the victim girl. Though learned counsel for the petitioner is absent, our learned additional public prosecutor has submitted that in paragraph number 2 of the aforesaid bail order, it instead of mentioning the relevant PS case number as Gosaigaon PS case number 506/2021, it has been stated therein as Gosaigaon PS case number 2025. So I have perused the records of bail application number 2663/2025. It appears that aforesaid error has been crept in the said order due to inadvertent typographical mistake and same required to be rectified. So, as such, this interlocutory application is allowed and it is directed that the mention of the police station case number, Gosaigaon police station case number as 506/2025 in paragraph number 2 of the aforesaid order shall be read as Gosaigaon PS case number 506/2021. This interlocutory application is accordingly disposed of.
May I please, Your Honor? My lord, this transfer application is for transfer of my lord proxy civil case number 638 of 2024. Filed by the my lord respondent husband, my lord. Wherein the respondent has been paid for dissolution of marriage by decree of divorce, my lord.
Who has filed
The husband, my lord, respondent husband, my lord. And the same is pending, my lord, in the court of principal judge.
You are husband or wife?
Wife.
Where it has been filed?
The court of principal judge, family court number 3, Kamrup, Guwahati.
Where do you want it?
My lord, in the court of my district judge, Lakhimpur, my lord. And my lord, some subsequent development is there, my lord. I have that pending case is filed by the my lord husband for seeking dissolution of marriage, my lord, by your decree of divorce, my lord. In the, my lord, I have got a telephonic instruction that the wife, my lord, the petitioner has no objection to that, my lord, the divorce, my lord. So may I pray that we both file a my lord joint petition before this honorable court, my lord, for my lord, as regards compromise, my lord.
No compromise, we are dealing with a transfer application only. If you don't want transfer, this can be withdrawn. But main case has to be decided by the family court. We cannot interfere in transfer juris while deciding transfer application in the main case.
It will also may hear the matter on my lord, maybe it's my lord, this transfer petition. But, may I argue my,
No, if you don't have an objection,
as per my telephone instruction, my lord.
then you seek instruction that whether you want to pursue this transfer application or not. If wife does not have any objection,
We have to file the application before the family court, my lord.
yes. Admitting the contentions. Then what is your submission?
Then my lord, I will take instruction.
Instructions. At Mr. A. Sharma,
Also,
R. Sharma, learned counsel for the petitioner. Also at Mr. R. Sharma, learned counsel. Also at Mr. A. Sharma, learned counsel for the respondent. Learned counsel for the petitioner submits that though the petitioner, who is the wife of the respondent, had filed this transfer application for transferring the
Case 37.
Title suit,
No, FCC bill, my lord.
FC civil case number 638/2024 from the court of Principal Judge, Family Court number 3, Kamrup Metro, to the court of Learned District Judge, Lakhimpur, however, in the meantime, there is a development in this regard, in as much as the wife does not have any objection if the divorce is granted to her by the said court. Under such circumstances, learned counsel for the petitioner submits that he may be granted some time to take necessary instructions from the petitioner as to whether the petitioner intends to pursue with the instant transfer application or not. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by the registry.
Obliged. The interim order, sorry, my interim order is already on the. No.
Item 10.
Yes.
Yeah, please, Lordship. Lordship, appeal under section 23 of Railway Act, Lordship. Notice may be issued, Lordship.
This appeal is under Railway Act. Whether any substantial question of law is required under the Railway Act. Railway Act, so. Section 23. Any substantial question of law is required.
My lord, there is already various judgment of our Honorable High Court in this proposition.
What?
My lord, such as in the present matter, these seals and card labels been missing in the shortage of the consignment. And our Honorable High Court has held that absence of seal and card label would amount to negligence of the railway under section 93 and would amount to criminal enterprise.
No, my query was different. Whether in an appeal under Railway Act, any substantial question of law is required to be formulated. Yes or no?
My lord, in this matter, there is no such substantial question of law is required.
Yes, say boldly.
My lord,
Say boldly, yes or no.
My lord, there has been non-compliance of discovery order 11 rule 21 and the laws are very much settled. There's no new question of law has to be derived, my lord. However, there has been, whether there has been compliance of discovery application or not, that has to be considered, my lord. Whether absence of seal and card label would amount to
This
criminal
appeal is under section
23 of the Railway Claims Tribunal Act.
Railway Claims Tribunal. Heard Mr. D. Rathi, learned counsel for the appellants. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been filed by the appellant, impugning the judgment and order dated 22/8/2025, passed in original application number OA within bracket 1/GHY/41/2019 hold by the Railway Claims Tribunal Guwahati bench, whereby your claim was dismissed,
Yes, ma'am.
whereby the claim preferred by the present appellant was dismissed. Issue notice to the respondent. You have not served notice.
Copy has been duly served to CGC, my lord. CGC have been appearing for the railways. Deputy SGA name has been mentioned, ma'am, in the cause
Yes.
list.
Since the appellant has served the copies of memo of appeal and notice to the London Central Government Council, no formal notice need to be served, issued to the respondent. This appeal is admitted. Call for the records of original application number OA, number to लिखिए from the concerned Railway Claims Tribunal. Release this matter after 4 weeks on receipt of the trial court records.
Deeply obliged. Item 11.
Yes,
Lordship, this is a regular first appeal preferred against the judgment and decree dated 21/3/2025, passed by the learned civil judge.
heard
Senior
Mr. What is the name?
Lordship Z. Datta.
Heard Mr. Z. Datta, learned counsel for the appellant. This appeal under section 96 of the Code of Civil Procedure 1908 has been preferred by the appellant against impunity, against the judgment in decree dated 21/3/2025, passed in title suit number 116/2021 by the Court of Learned Civil Judge, Senior Division, Kamrup at Amingaon, whereby the suit filed by the present appellant was dismissed. Issue notice to the respondents. The appellant shall take steps for issuance of notice by speed post within 7 days from the date of this order, returnable after 4 weeks. Let the records of trial court be requisitioned. Registry to take steps for requisitioning the records. Release this matter after 4 weeks.
13.
Statutory,
Lordship, this is statutory appeal, Lordship, preferred by the influence control.
heard Mr. S.P. Sharma, learned counsel for the petitioner. This appeal by the appellant insurance company has been preferred under section 173 of the MV Act, impugning the judgment and order dated judgment and award dated 11/9/2024, passed in MSC case number 769/2029 /2019 by the Court of London, by the Motor Accident Claims Tribunal, number 3, Kamrup Metro and Guwahati, whereby the present appellant was directed to pay a compensation amount of rupees 12 lakhs 11,000 only to the claimant respondent with an interest of 9% per annum from the date of filing of the claim petition. Issue notice to the respondents. The petition, the appellant shall take steps for issuance of notice upon the respondents by
Lordship, can we take that step by ordinary process, Lordship, because by speed post, Lordship, it will be.
no speed post also. No, not by ordinary post. By speed post. Otherwise, it will be difficult to track.
Lordship, in the speed post, there will be no AD card, that is a difficult.
No, but consignment, track consignment report will be available. Speed post. Within 7 days from the date of this order. Returnable after 4 weeks. Let the records of the concerned MSC case be called for from the tribunal registry to take steps for requisitioning the records. Release this matter after 4 weeks.
In the positive, Lordship, the name of my senior, Mr. R.D. Majumdar, has been wrongly mentioned as Mr. R. Majumdar. Or Mr. D. Majumdar. So that may be corrected. Otherwise, it will be.
Learned counsel for the petitioner has submitted that name of the engaged counsel for the appellant has been wrongly mentioned as Mr. D. Majumdar in the cause list instead of Miss R. D. Majumdar. Registry to rectify the defect and reflect the correct name of the engaged counsel for the appellant in the cause list henceforth. List accordingly.
Deep privilege.
Item 14.
May it please your lordship. This appeal is preferred against the judgment and order dated 28/7/2025, lordship. Passed by member MSCT Morigaon, lordship.
Third, Mr.
S.J. Sharma, lordship, on behalf of A. Borwa, lordship.
S.J. Sharma, appearing on behalf of Mr. A. Barwa. This appeal under section 173 of Motor Vehicles Act has been preferred by the appellant, impugning the judgment dated 28/7/2025, passed in MSC within bracket injury case number 139/2019 by the Motor Accident Claims Tribunal, Morigaon. Your claim was dismissed.
Claim was not dismissed, but claim was the amount of compensation
Enhancement.
not satisfactory.
Stop. The appellant is agreed mainly with the quantum of compensation awarded to him and has approached this court for enhancement of the said award, said quantum. Issue notice to the respondents and call for the records of MSc injury case number 139/2019. The appellant shall take steps for issuance of notice by speed post within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
My apologies, Lordship. In item number 30, there is a stay petition also. So we are ready to deposit 50%.
Item number 30. 1-3. Heard Mr. S.P. Sharma. This interlocutory application has been filed by the applicant impugning the praying for stay of the execution of judgment and award dated 11/9/2024 passed by the Motor Accident Claims Tribunal number 3 Kamrup Metro in MSc case number 769/19. Learned counsel for the petitioner has submitted that by the said judgment and award has been impugned by the present applicant by filing the connected MSc appeal number 518/2023. By the impugned judgment, the applicant was directed to pay a compensation of rupees, how much?
12 lakh, Lordship. 12,11,000.
12,11,000 along with 9% interest per annum from the date of filing of the claim petition to the claimants. Learned counsel for the petition applicant submits that the applicant is ready to deposit 50% of the awarded amount in the registry of this court as a condition precedent for staying the execution of the aforesaid award. Stop. I have considered the submissions made by learned counsel and have gone through the records. As the applicant is ready to deposit 50% of the awarded amount as a condition precedent for stay, this court is inclined to waive the notice to the opposite parties and dispose of this interlocutory application with a direction that subject to payment of 50% of the awarded amount by the present applicant before the registry of this court within a period of 6 weeks from the date of this order. The execution of the impugned judgment and award dated 11/9/2025 2024 passed by the Motor Accident Claims Tribunal number 3 Kamrup Metro in MSc case number 769/2019 is hereby stayed. This interlocutory application is accordingly disposed.
May please, Your Lordship. This appeal is preferred for enhancement against the judgment order dated 29/8/2004.
Heard Miss A. Burman, learned counsel for the A. Burman,
Lordship.
A. Burman, learned counsel for the appellant. This appeal under section 173 of the MB Act has been preferred by the appellant Abdul Salam impugning the judgment and award dated 29/8/2024, passed by the MACT, the Motor Accident Claims Tribunal, Sonitpur, in MAC case number 25/2019. The appellant is aggrieved with the quantum of the compensation awarded and has prayed for enhancement of the same in this appeal. The appeal is admitted. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by usual mode as well as by speed post within 7 days from the date of this order, returnable after 4 weeks. Let the records of MSC case number 25/2019 be called for from the concerned tribunal. The registry to take steps for requisitioning the record list accordingly.
May please the lodge. This application filed by the insurance company on the quantum of the award.
Third, Mr. B. Acharya.
Yes.
A. Acharya, learned counsel for the appellant insurance company. This appeal under section 173 of MV Act has been filed by the appellant insurance company, impugning the judgment and award dated 5/3/2025, passed by the Motor Accident Claims Tribunal. Number 2, Kamrup Metro at Guwahati in MSC case number 1564/2008. Issue notice to the respondents. And before that, this appeal is admitted. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondent by usual mode as well as by speed post within 7 days from the date of this order, returnable after 4 weeks. The registry to take steps for requisitioning the records of MSC case number 1564/2018 from the concerned tribunal, list accordingly.
Lordship, we have filed an IA for stay.
Pay 50%. গরম পানি নিবে। Not so and so. This interlocutory application has been filed by the applicant insurance company praying for stay of the execution of the judgment and award dated 5/3/2025, passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro in MAC case number 1564/2018. The applicant has impugned the aforesaid judgment and award by preferring the connected MAC appeal number 524/2025. The applicant/appellant is aggrieved mainly with the quantum of the award, quantum of the compensation awarded to the claimant respondent. Learned counsel for the applicant submits that the applicant is ready to deposit 50% of the awarded amount as a condition for grant of stay of the execution of the impugned judgment and award. Considering the submission, the notice to the respondents is waived. And this interlocutory application is allowed. The execution of the impugned judgment and award dated 5/3/2025 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro in MSC case number 1564/2018 is hereby stayed, subject to deposit of 50% of the awarded amount by the applicant before the registry of this court within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed.
Clear, please.
The appeal has been recorded against the order dated 19/5/2025 passed in Mirzay case number 129/2024, whereby the delay condonation in the before the learned first appellate court has been rejected. Okay. Page 68 is the order of the learned first appellate court whereby the delay application has been rejected. Your Honor.
What is the substantial question?
Chief, I have already. In page number 4, Your Lordship.
Where is your memo of appeal? Memo of appeal is absent. It is before the judgment or after the judgment?
First, it is after the judgment of the trial court. Trial court judgment was passed on 18th of January 2022. Thereafter, there is a delay of 974 days in preparing the first appeal.
Thank you. Flag করে দিবেন। Flag the memo of appeal. Or we'll take it up as next item. You flag the memo of appeal and the substantial question.
Thank you.
Yeah, please, Your Honor. My lord, this matter may be adjourned for the time being, my lord. My senior is on in the case code number 6, my lord. Or if it is possible, it may be listed in the next meeting.
On on request of learned counsel for the appellant, list this matter in the next week on a date to be fixed by registry.
Order item 20.
You ready, Ole Matthew?
May I please your lordship, that dusty service is complete and the LCR is also received. Matter may be fixed for hearing.
Miss, what is your name?
E. Bordula.
P. Bordole. P.
P.
P. Bordole, learned counsel for the appellant. Oh. How many respondents are there? On perusal of the office note dated 10/11/2025, it appears that the notice issued to sole respondent by Dusty Mode has been duly served. An affidavit in compliance has also been filed by the appellant. Stop. I have gone through the affidavit filed by the appellant, whereby it has been stated that the notice has been duly served on the sole respondent. A copy of notice is also annexed along with the affidavit, where the seal of the respondent T state has been put along with the signature of the recipient. So in view of the aforesaid affidavit, the notice issued to respondent number 1 is held to be duly served. Let this matter be listed for hearing in,
Last week of December.
let this matter be listed after 4 weeks.
Item 21.
Please, your lordship. In this case, I am for the appellant, lordship. My injunction prayer was rejected by the learned trial court, and against that this first appeal against order, lordship. Respondent number 2 to 5 appeared. 1 died, lordship, but I have information that she was already substituted in the pending suit, lordship. And government is respondent number 6, 7, 8. And 9 to 21, I have already prayed for striking out the name, lordship, as because they are pro forma. On last occasion, Mr. M.H. Rajbarbuya appeared for 2 to 5, lordship.
Yes. Now, service in respect of which respondent is remaining,
Lordship, only 1 died.
what will happen?
Our lordship, at the time of issuing notice, already status quo was granted by this court. And the suit proceeded for argument. Thereafter, a petition was filed for scientific expert opinion. And the suit is at the stage of scientific expert opinion, lordship, on that the unregistered sale deed. At this stage, lordship, May I pray to maintain that status quo till disposal of the suit and dispose of this FAO, or your lordship may fix it in admission column on some other.
No, if status quo has already been granted,
Granted,
and
lordship.
if you don't want any further relief, you can withdraw this appeal
No, lordship, status quo granted by this court only.
on this court.
Yes, lordship. While issuing notice on 14/6/17,
Then that will continue.
lordship.
And what will happen to respondent number one?
Respondent number one, lordship, already implemented by the respondent before the trial court, lordship, by the defendant.
But before this court,
She was not substituted.
this has to be done.
This has to be done, lordship. Now I have to file three applications, lordship.
That has to be done.
Lordship.
We'll continue the status quo. Heard Ms. R. Chaudhary, learned counsel for the appellants, also heard Mr. T. R. Gogoi, learned counsel for respondent number
6, 7, and 8, Lord.
6, 7, and 8. Though on last occasion, Mr. M. H. Rajbur Bhuya appeared for respondent number 2 to 5. However, he is absent today. It also appears that by order dated 10/11/2025, the names of respondent number 9 to 21 were struck off from the memo of appeal. However, it appears there is office note or regarding death of this one.
Last occasion, Mr. Rajbur informed the court.
However, learned counsel for the appellant submits that on the last occasion, no. However, on perusal of order dated 10/11/2025, it appears that on that day, learned counsel for respondent number 2 to 5 had informed this court that respondent number 1 has already expired. So, in view of the above, learned counsel for the appellant seeks some time to take appropriate steps in view of the death of respondent number 1. Stops. Prayer is allowed. Let this matter be listed after 4 weeks. After 2 weeks, the interim order granted earlier shall continue till next date.
May I pray for a date on 3rd of December, lordship? Or lordship 10th of December. lordship.
Let this matter be listed on 10th of December.
Obliged.
Item 18.
Now, this is a question of fact. Whether it can be gone into.
Otherwise, your lordship, the only reason the first appeal was dismissed is that without going into the merit of the case, it has been dismissed on the ground of delay, your lordship.
No, how merit can be gone into while considering a delay condemnation application.
Otherwise, I have explained it that the reason behind it is that the defendant, the present appellant, he has been convicted in a session case and he was behind the bar for past 4 years. And during that particular period, even though the judgment was decided inter-party, none has appeared on behalf of the defendant. No evidence has been laid before the learned trial court from the defendant's side, your lordship. Only the written statement has been filed and thereafter there was no steps taken by any advocate on behalf of the defendants. And as such, the suit proceeded against me. A judgment has been passed, a decree has been given, and as on date, a title execution has also has already been filed. Your Lordship.
Okay. Heard Mr. G. Bordole,
Lordship.
learned counsel for the appellant. This regular second appeal has been filed by the appellants under section 100 of the Code of Civil Procedure 1908, impugning the order dated 19/5/2025, passed by the Court of Learned Civil Justice Senior Division, Borpeta, in Miss Case number
129.
Miss J case number 129/2024 in connection with title appeal number 53/2024, whereby the trial court, whereby the first appellate court declined to condone the delay of
75 days. back.
75 days in preferring the first appeal before the said court against the, which is the trial court's order?
Trial court order, Lordship, will find it at page number 29, Your Lordship. That is the judgment dated 18/1/2022.
Against the judgment dated 18/1/2022, passed in
Asked in title suit number 368 of 2014.
title suit number 368/2014. Stop. After after considering the submissions of learned counsel for the appellant and going through the materials on record, following substantial question of law is framed in this appeal. Whether the first appellate court order, whether the impugned order of the first appellate court passed in Ms. J case number 129/2024, whereby it declined to condone the delay of 975 days in preferring the connected first appeal, is perverse. Question mark. This appeal is admitted. Issue notice to the respondents and call for the records of the first appellate court. Records of the Ms. J case number 129/2024, as well as title appeal number 53/2024 from the Court of Learned Civil Justice Senior Division, Borpeta. Registry to take steps for requisitioning the aforesaid records. The petitioner, the appellant shall take steps for issuance of notice upon the respondents by usual mode as well as by speed post within 7 days from the date of this order, returnable on after 4 weeks. Please this matter after 4 weeks.
Okay, there's a high cost of the
What stay here?
Judgment, Your Lordship. It is in title suit number 368 of the because the execution is already pending, Your Lordship. They have already preferred an execution and which is pending before the Munsif Borpeta, Your Lordship.
Notice will go.
Lordship.
Mr. G. Bordaloi, and counsel for the applicant. This application under order 41 rule 5 of the Code of Civil Procedure has been preferred by the applicant praying for stay of the execution of this order cannot be stayed.
Lordship.
The order would be, you are agreed by the order of the trial
Trial
court.
court.
The execution of the, where is the trial court's order? Order of the judgment and decree of the trial court dated 18/1/2022 passed in trial court or within bracket लिखेबो Municip number 1 Barpeta passed in title suit number 368/2014. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents within 7 days from the date of this order by usual mode as well as by speed post. Returnable, we will give a fixed date. If returnable on 18th December, is accordingly.
22.
I got to returnable on 18th.
May it please your lordship. Lordship, as per honorable court's order dated 26/9/2025,
Yes,
as per honorable court's order dated 26/9/2025, we have taken steps on the respondents number 5 and 6 through paper publication, lordship. And the same has been placed at flag A. And respondent 1 to 4 are duly represented.
where is the paper? Where?
Flag A.
Seventeen 11. Okay. Heard. Miss, what is your name?
If-
K. Bora, learned counsel for the applicant. / appellant. Also heard Mr. T.R. Gogoi, learned counsel for respondent number
1 to 4.
1 to 4. Learned counsel for the applicant / appellant has submitted that in pursuant to the directions of this court by order dated 26/9/2025, the appellant have taken steps for issuance of notice by substituted mode by publishing the notice in the newspaper. Which newspaper? Navavarta Prashanta. Propongo. Dated
1/11/2025.
1/11/2025. So The copy of the said newspaper has been placed in the record at Flagler. On perusal of the said newspaper as well as the notice published therein, this court is satisfied that the notice to respondent number 5 has been duly served. Respondent number 5 and 6. Respondent number 5 and 6. Uparato 5 and 6. Duly served. What is this IA for?
I is for condoning delay of 2 days.
Days.
Lordship, only 3 days delay, Lordship. I don't have any objection.
The date is fixed today in the notice. We'll release this matter tomorrow or day after tomorrow. Okay. Duly served. Let this matter be listed again on 19th of November 2023 in orders column.
Highly organized.
Obliged.
Item 23.
Please, Lordship. I appear for the respondent number 1, my lord. So, my lord, appellant filed this case in the year 2022. Notice was issued. The appeal for my lord enhancement of the awarded amount. So, my lord, office note dated 11/11/25. It's not served. So they are the owner and driver. I think it's not necessary. So LCR also, my lord, received. And please for it.
What is to be done?
I think, my lord, since it is a appeal for my lord enhancement, so I think owner and driver is, we have already satisfied the awarded amount. So they filed this case for enhancement in regard to the income as per memo of appeal.
No, but appellant is absent.
This is a date may be fixed on another. 20.
Heard none has appeared for appellant on call. Heard Mr. R.C. Paul, London, counsel for respondent number 1. Office note does not reflect anything about regarding service of notice on respondent number 1, 2 and 3. The registry to verify and put up this record again after proper office note. Let this matter be listed.
So date will be
No,
after 1 week.
after 1 week.
Much.
25.
Your lordship. My lord, as per office note dated 19/6/25, lordship. Respondent number 1 and 2 already represented lordship, but AD of respondent number 3 has not been received back, lordship. And notice was issued, lordship, on 6/5/24. May I pray that I may be allowed to take fresh steps upon respondent number?
Yes.
Your Lordship, I have a prayer as well. Your Lordship, as per order dated 1/6/2022, in the present IA Civil 151543/22, 50% of the awarded amount is deposited by in the Registrar General Office. The claimant number 1 and 2 may be with the liberty to withdraw the amount, Your Lordship.
You will file a written application. They have objection. So no oral prayer. Heard Miss M. Chaudhary, London, counsel for the appellant. This is item number
55.
Also heard Mr. A. N. Iqbal appearing for respondent number 1 and 2. Learned counsel for the appellant submits that since service report in respect of respondent number 3 has not yet been received, the appellant may be allowed to take fresh steps upon respondent number 3. The prayer is allowed. The appellant shall take steps by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Not applies, Lordship.
You file an application.
Please, your lords.
Yeah, please, your lordship. Lordship, in this case, what had happened is the case was dismissed for default. Thereafter, there was a restoration application filed and there was a delay of 126 days. And the delay has already been condoned by this honorable court by order dated 1/8/25, your lordship. The 126 days delay. Now, this is the consequential restoration application. The grounds are same with regard to the condonation application because why the case was dismissed and the delay was the same, your lordship. So I may be, as the delay has already been condoned,
Delay condonation application.
it has been condoned in IA Civil 737, your lordship. It was by this honorable grounds, which has been urged before this honorable court in this instant restoration application, is the same ground in that appeal. And para 3 of that order reflects
Yes,
that.
you have any objection?
No, I do have an objection, my lords.
Okay,
if
then let them satisfy the court.
My lords, if my lord says,
No, before,
that-
let him satisfy.
very well.
Now your lordship may kindly come to my application, your lordship. Now. in
No,
this
on
case,
what
recognizes
ground
that
delay
the
was condoned?
The case was filed,
No. On what ground delay was condoned?
the ground is para 3 of your the order, your lordship, in the order dated 1/8/25.
Read it.
This is the ground which has been taken note of.
Please read.
The arbitration appeal was initially filed in the Aizawl Permanent Bench. Later on, at the behest of the application, the Honorable Chief Justice directed to transfer of the said arbitration appeal to the principal seat. The learned counsel of the applicant submits they did not know when the arbitration appeal actually came to the principal bench. Thereafter, he could not appear in the appeal on several dates, and as a result, the arbitration appeal was dismissed. He filed the restoration petition supported by the present petition under section 5 of the Limitation Act. And
Okay.
this was the.
This
thing-
was found to be sufficient. now.
Sufficient. And this is the same ground which I have urged through this restoration application. So that para is in synopsis of my entire case, your lordship, but it summarizes the entire facts, your lordship.
When it was dismissed for default,
It was dismissed for default. If your lordship sees the order, I have annexed that particular order. In this particular application, your lordship will find at page 28, your lordship. It was dismissed on default on 26/9/23. If your lordship has got it, page 28. This is an order, none appears from applicant, hard sir, Mr. A. Roy. Today is the third day applicant is absent on call. The court is of the opinion applicant has failed to prosecute the matter. Accordingly, interlocutory application is dismissed for default. So once this application was dismissed, so
And against that, we had come, your lordship. The interlocutory application was a delay continuation application in the section 37 application of the Arbitration and Conciliation Act.
Yes.
Well, if my lord says para 8 of the order, last order, Milos, it says
Para 8 of which order?
of the order dated 1st September, August.
This para 8, there is no.
Which order?
No, para 6, para 6.
Of the delay condemnation application.
Yeah, where it was allowed, Milos. Order is 1st August 2025, the order, Milos.
Yes.
Say the connected restoration petition shall be registered and shall be listed for admission. So what was allowed, Milos, is basically the condemnation of delay application.
Yes.
There are two rules which govern this. Section 122 of the Limitation Act, Milos, of 1963 deals with the condemnation of delay. Rule 19, Order 41 of the CPC deals with the restoration. So there are two different. One is substantive, one is procedural, Milos. Now the restoration, what has been allowed is condemnation of delay of 126 days. Ground, sufficiency of the cause for restoration. What prevented him? Because he's putting whole of the onus on the registry. And is that a valid or sufficient cause? That what I need to demonstrate to my lords.
What is the requirement of order for?
Rule 19, Milos. Of
Order 41.
41. May I read, Milos? Where an appeal is dismissed under Rule 11 and Sub-Rule 2 or Rule 17, the appellant may apply to the appellate court for readmission of the appeal, and where it is proved that he was prevented by any sufficient cause. So, the underlying ingredients of Rule 19 or 41 is that he has to prove that he was prevented from any sufficient cause. Whereas, Milos, Section 22 of the Limitation Access for Restoration, it has to be filed within 30 days, which was filed much beyond. It's not only, Milos, 126 days delayed, if I consider from his letter of request when he
delay part is over.
Yeah, delay part is over. No, I'm saying it was delay of much more than 126 days since the time he moved the IJOL bench, this honorable court, for transfer of the matter is 213 days, Milos, and its conduct also, Milos, right from day one. If I can just in 2 minutes briefly give my lords the background to this, so that it's easy for my lord to appreciate what has gone so far. So there was an award, Milos, which was passed on 8th November 2019. Section 34 was preferred by the department, the Public Works Department.
But while considering this case,
It becomes relevant conduct, the sufficient, because there was delay in filing 37, which is still pending, because his 37 has not been registered because there is an application for condonation of delay. Even in 37, there was delay, which is still pending, Milos. That's how the 37 also has not been registered. Thereafter, Milos, as the matter was not moving before the particular bench, they moved a letter for transfer to this honorable court. The matter got listed here on their request, and they had the knowledge, that I'll demonstrate if from their application, there's an admission that when the matter was being transferred to this honorable court, a copy of the intimation was given to them. If my lords has their application, it's evident. So the fact has to be brought subject to what my lords decide. I just want to put the correct fact before this honorable court. That's all, my lords, and the law. And then I leave it to my lord's discretion to allow or not to allow. If my lord says their application 737, which is an application for restoration, because condonation I'm not dealing with, that is done away. That's now set at naught. If my lord says that application on page
20,
page 5 of his application, Milos, para 3, page 5 of the application, Milos. Has my lord got that?
yes,
May I read, Milos?
page 5 para.
Para 3, Milos.
There is no para 3.
starts from page 4, your lord.
Yeah. In mine, you have yours is page 5.
Which application you are referring to? You are seeing the condonation of delay application. 737 is.
Milos, page, so if I may read it, Milos, that the petitioner begs to state that that subsequent to the issuance of the aforesaid letter by the petitioner on 26 June 2023, the case records pertaining to the aforesaid to case being IA arbitration appeal number 01 of 2022 and IA so-and-so civil of 58 of 2022 were transmitted from the Aizawl bench of the Honorable Guwahati High Court at Aizawl to the principal bench of the Honorable Guwahati High Court at Guwahati by the Assistant Registrar Judicial, Guwahati High Court, Aizawl bench by a covering letter dated 29th June. So, they make a request on 26th June, on 29th June. The same is transferred to this Honorable Court. It is opposite to place on record the fact that a copy of the aforesaid mentioned forwarding letter was informally handed over to the petitioner by the office of the Assistant Registrar Judicial, Guwahati High Court, Aizawl. So, when on their request, it is transferred. When it is transferred, the intimation is given to them. Am I? Thereafter, on 31st July, 22nd is they give a request letter for transfer. On 29th, it is transferred with intimation to the applicant here in Milos. On 31st July, 2023, the application was listed for the first time before this Honorable Court. No one appeared on their behalf, Milos. It again gets listed, Milos, and adjourned on 25th of August, 2023. Nobody then again appears, Milos. Thereafter, Milos, on 26th of September, when the matter got listed for the third time and no one appeared on their behalf, Milos, this Honorable Court was pleased to dismiss the matter. As a sequitur, Milos, as the application for condonation was dismissed, therefore, the main appeal also by a logical sequitur got dismissed. So this is the current position because it's not numbered, because 37 has not been numbered because there is a condonation of delay application. I'll also appreciate what I'm trying to say. When they filed the 37, it was not registered because there was a delay in filing the 37. So there was an application for condonation of delay.
That got dismissed.
That got dismissed. So accordingly, the appeal also, because it's not registered by logical sequitur, gets dismissed. Because it's not numbered. It's not
Your
numbered.
submission is that because of the forwarding letter,
yes,
they were aware about the transfer of.
No, I'm coming to that. It's all. It's not only forwarding letter. It's almost a gap of, if my lord will see, 7 months. They have not. The blame that they are looking at, or the ground that they have made out in the application, for restoration is that the registry on receipt of the file from the Aizawl bench did not intimate to the applicant of the listing and renumbering. There's two grounds that they have taken. And there was a legitimate expectation that
No, what ground they have taken?
First was,
If I may be allowed.
let me summarize it, then you can say,
I
sir.
put my case.
We'll-
He has taken the matter. But my grounds are specifically stated.
We'll come to you. You should not interrupt.
So, there are 4 grounds. First ground was, he says, it was incumbent upon the registry of the Guwahati High Court
Where are those grounds?
in his application,
Page.
if my lords can come to page
8.
8, Milos. Para 7, it starts, para 6, Milos, if I may be. Para 6, 7. May I read, Milos? It says
Yes.
that the petitioner begs to state that it appears from the record which are presently available with the petitioner that after the renumbering of the application which filed by the petitioner under Section 5 of the Limitation Act 1963, being IA number civil 2008 to 2023, was listed thrice before the concerned bench of the Honorable Guwahati High Court, the principal seat on 31st July, 28th August, and 26th September. However, as the petitioner and his engaged counsel were completely in dark about the renumbering of the said case and their subsequent listing before the concerned bench of the Honorable Guwahati High Court, the principal bench, on the aforementioned dates, the petitioner remained unrepresented before the Honorable Court, resulting in the said IA number 2008-2023 being ultimately dismissed for default by the Honorable Video Court, order dated 26 September 2020. So he also admits it was 2008-2023 being dismissed, which was an application renumbering of the 37. Now, Milos, if I come to straight to Milos, para 13.
Arbitration appeal was numbered at Aizawl bench.
Yes, Milos, it was numbered.
But here the system is that appeal is numbered only after the condonation of delay
It has to be
application. is there.
admitted also. It was numbered and admitted also. Yeah. Because till the time Milos, delay is not condoned.
No,
Even-
when the appeal was transferred to this case,
Yes, Milos.
to this bench,
Yes, Milos.
as it was numbered earlier in the,
01. Yes, right. Milos.
what number was shown in the cause list?
Here it was shown as 2008 of 2023, which is also borne out from his pleadings in paragraph 7, Milos. Last two lines of that paragraph.
The order sheets are annexed.
Which says before the resulting in the said IS.
So no numbering was given to
Yes, Milos.
the appeal.
Yes, Milos.
The number
Because-
was removed.
Yeah, no, because it was only a recording number memo. That's what I understand from my brief here. Because as the appeal, it was only on transfer till the time condonation of delay application is not allowed. There is no admission of the main appeal. It's to inform the applicant. So, Milos, we'll have to look at how the High Court and Supreme Court has looked at it. Because now it has become a routine. The Supreme Court says it has become a routine affair to blame the registry. I'll make that good submission by way of a precedent also.
Okay.
So, Milos, what I'm saying is, so Milos, in 3 days they don't appear. And for the first time in January 2024, Milos, even September, my laws will look at the days. So, Milos, 26th September 2023, it gets dismissed. And for the first time, how vigilant is the applicant, Milos, will be borne out that he, for the first time in January 2024, on 29th January, with the letter which they have annexed, a mail was sent by the applicant to the council on record, Mr. Biswas here, which was, Milos, 213 days after his request for transfer, almost a year, Milos, almost 9 months, Milos, I would say. So he inquires about the status of his matter only after 9 months, that though he makes a request of transfer because the matter was not being heard, but he inquires from his local council because Mr. Biswas was dealing with his other matters here previously. Therefore, he writes a mail to please figure out what has happened to this matter. So, and on 5th of February, Milos, on 2024, Mr. Biswas got the knowledge of the dismissal order. 8th of February 2024, Mr. Biswas applied for the certified copies of the order. And as I understand from their pleading that on 19th February 2024, allegedly the papers were sent from the local council of Aizawl to the local council in Guwahati Millots, and which were received by Mr. Biswas. And in March 2024, the present application was filed. So my lord will see, in June 2023, he makes a request for transfer. And in June, again, they move an application for restoration. How vigilant? Because if I file a case, Millots, I need to be vigilant. That's what the courts have said all along. And on 24th April, Millots, this application was issued on the present application. And the 4 grounds that they have taken up, let me summarize the grounds, Millots, for the benefit of my lords. First ground that they have taken is, it was incumbent upon the registry of the Guwahati High Court to inform the applicant of numbering and listing of the appeal upon transfer of the appeals. Second, it says, Millots, it was a legitimate expectation of the applicant to expect the registry to provide such information. Therefore, Millots, when I don't do my duty, it's not a tender, then I file a bid and I'm the lowest bidder, there is a legitimate expectation that I'll be declared as an L1. He said there was a legitimate expectation when I am not a diligent, I'm not prosecuting my case diligently, but he has a legitimate expectation that the registry should have informed him. Third, Millots, he says JP was not negligent or careless in seeking restoration of the appeal. And lastly, Millots, he says there was sufficient cause for the delay. I just want to cite a couple of judgments on this, Millots, and I then leave it to my lord's discretion. So if my lord, and I'll just refer to a couple of the documents on record, which has been filed by my learned friend also. So, Millots, if my lords has come to annexure I on page 18 of his application, Millots, if my lords has his application, annexure I at page 18.
Yes.
That is his letter.
For transfer.
Transfer, Millots. Annexure 2, Millots, sorry, no, annexure 1, annexure 2 on page 20, Millots. This is dated, Millots, 22nd June 2023. Annexure 2 is, Millots, 29 June 2023. This is with regard to intimation, we has admitted he has got it also, of the transfer of the matter. Thereafter, Millots, if my lords can turn to page, then there are the 3 orders, Millots, when the matter was listed. If my lords can then come to page 29 in annexure 6, Millots. This is the first time in January, after June 23, in January 24, the applicant himself writes to his local council. This is important, Millots. This letter is important. I'll read it. As you are aware that I had filed an application under Section 37 of the Arbitration and Conciliation Act 1996 before the Aizawl bench of the Honorable Guwahati High Court, and which had been numbered as Arbitration Appeal number 1 of 2022, and had along with the same also filed an additional application being IAC Civil 58 of 2022 for challenging the order dated 30th 11/2021. Passed in the arbitration petition number 1 of 2022 by the additional district judge. Now, as the said appeal of mine was pretending since long, I had on 22nd June 2023 wrote a letter addressed to the Honorable Chief Justice of the Honorable Guwahati High Court seeking transfer of the said arbitration appeal of mine to the principal seat of the Honorable Guwahati High Court due to long pendency of the same. Now, therefore, thereafter, in the month of June 2023, 2023, it was informed to me by the Assistant Registrar of the Judicial and Aizawl Bench of the Honorable High Court that the case record of the said arbitration case of mine has been transmitted to the principal bench of the Honorable Guwahati Court. So, my lords, after his letter, he only does the inquiry in January. That's what is indicated. Is that a sufficient cause, my lords, to condone the delay? Or to restore it? Condonation of delay is done, my lords. I'm not touching upon. Is it a sufficient cause for restoration? An applicant who has not been vigilant in prosecuting his case after he makes a request for transfer. And there has been constant delay.
When the letter dated 29 June was received by the council,
May please, my lords?
letter dated 29 June, that is annexure 2.
Yes, my lords.
When that letter was received by the council? In January?
No, my lord. It was given to him on the same day.
June itself.
June itself, when it was being transferred, which I spoke to my lords, in June 2023, he makes that admission also in this mail. And even in the application, when it was being transferred, in para, as I have shown to my lords, in para 3, bottom part, it clearly says it is apposite to place on record the fact that the copy of the aforementioned forwarding letter was also informally handed over to the petitioner by the Office of the Assistant Registrar, Judicial Guwahati High Court, Aizawl Bench. So when it was being transferred, the intimation of transfer was also handed over to the But they did not inquire, neither the council nor the applicant. Applicant for the first time only inquires sometime after that, moving that request in January 2024, almost after a gap of 7 months. So, we'll have to really ask, was the applicant vigilant? And if he was vigilant, is the sufficient cause as indicated by him in the present application is really a sufficient cause to restore his IA number 2008 of 2020. Just to aside Miller's couple of judgments on this, and will be done with it. Plus, the first judgment that I would like to say on whether it is sufficient cause or not is a judgment of Miller's Supreme Court. Deepak Kansal, improving. If I can you have it. I think I'd given it to you last time. Yeah. Milos, para 18, Milos, of this judgment. I'll start with 14, Milos, which is on page 811. If I'm first, I may be permitted to read para 14 on page 811, Milos. It says, the petitioner had filed this writ petition in a hurry. When it was listed, he circulated a letter to the effect that, as per the procedure, he expected that he would be called for interaction by the registrar of this court to find out his fitness, whether he could argue a case in person. The petitioner sought to know that he is an advocate of this court, and argues the matter in this court. As such, it was not necessary to summon him for adjudging his capability as to whether he could argue the case. Be that as it may, circulating such a letter was not appropriate at his instance, and why he doubted his ability to argue. There was no justification to entertain this kind of apprehension.
No, facts are different.
Yeah, I'll read it. Facts are different. Now, my loss may come to para 18. 15 and 18, Milos, in the same.
Yes.
18 is straight way, Milos. I'll not waste my loss. We see in general, this is important. 18, Milos. We see in general, it has become a widespread practice to blame the registry for no good reason. To err is human, as many petitions are filed with defects and the defects are not cured for years together. A large number of such cases were listed in the present past before the court for removal of the defects which were pending for years. In such situation, when the pandemic is going on, baseless and reckless allegations are made against the registry of this court, which is part and parcel of the judicial system. We take judicial notice of the fact that such evil is also spreading in the various high courts and the registry is blamed unnecessarily for no good reason. It is to be remembered by worthy lawyers that they are the part of the judicial system. They are the officers of the court and are a class apart in the system. What I'm trying here also, the Milos, is squarely, because there was delay in the pandemic. Squarely now they're saying when it got transferred, he had a legitimate expectation of being informed by the, instead of his inquiring or being vigilant in prosecuting his matter, he expected that registry should inform him. Which is, Milos, as per the procedure, Milos, to the best of my understanding, I don't think it is incumbent upon the registered or if there's any way of prescribing the materials or the Guwahati High Court rules that on a transfer, it is incumbent upon the registry to inform the applicant of renumbering or the date of hearing or transfer. It is not there. That's, I'm saying, Milos, to the best of my ability. I've checked. It is up to him to say that once it is transferred, it is incumbent upon the registry as per the Guwahati High Court rules to inform them of renumbering and on the date of the listing. Second judgment, Milos, I would rely upon is, this was on the blaming of the registry, Milos, how the Supreme Court has dealt with it, because this has become a routine procedure now. Second judgment, Milos.
Yes.
This is, Milos, a High Court, a second, Delhi Work Board, Milos. Para 5 and 7, Delhi Work Boards. Yep. Yes. What is like
There are 5 and
7, Milos. It's basically, Milos, a litigant is required to be vigilant and pursue his skills diligently on all the hearing. Para 5, Milos, if I may be permitted to read.
yes.
It is well settled principle of law that a litigant, whether it is an individual or a government body or any legal entity, it owes a duty to be vigilant of its rights and is also expected to be equally vigilant about the judicial proceedings pending in the court of law against it or initiated at its instance. This is important. Now, after 21 years, the applicant cannot be permitted to blame the previous counsel for not providing them the records of the case. The applicant is not an individual, but a government legal entity having a proper legal department with several law officers who know very well where their interests lie, is expected to have the entire record with it. It appears that the blame is being attributed to the previous counsel with a view to get the delay condoned. After filing of the revision petition, the applicant cannot go off to sleep and wake up from a deep slumber after the passage of a long 21 years, as if the court is a storage of the petition filed by such negligent litigant simply because there is a change in the management cannot give sufficient cause to the applicant to file such an application for restoration after a long period of 21 years has elapsed. It is also not made clear how many times the management has been changed after the dismissal of the revision petition in default. The details of such changes in the management have also not been given. The litigant is to be vigilant. This is important. The litigant is to be vigilant and pursue his case diligently on all hearings. If the litigant does not appear in the court and leaves the case at the mercy of his counsel without caring as to what has happened on the date fixed, he is bound to suffer. So, Milos, he files in June transfer. Thereafter, he doesn't care. It's only he wakes up in January 24. That's what I am trying to demonstrate. He has not been vigilant, not diligent in pursuing his case. He can't leave it to the mercy of the council because he himself in petitioner in person filed that request for transfer of the case from Aizawl to the Honorable Court. Now, Milos, on this para 7, Milos, I read it. To conclude, the necessity for enacting period of limitation is to give effect to the principle that law does not assist a person who is inactive and sleeps over his rights. The principle which forms the basis of this rule is expressed in the maxim vigilantibus non-determinantibus jura subnovint. The law helps those who are watchful and not those who are asleep. Therefore, the object of the law of limitation is to compel a person to excuse his right of action within reasonable time, as also to discourage and suppress state fake of fraudulent. So, Milos, I'll just conclude by citing the last judgment of the Supreme Court, Milos. Whether does it constitute a sufficient cause? Basavura. Which one are you? I'll say one more judgment, Milos, Parimal. Parimal, you're taking first.
Which one?
Which? Yeah. Yeah. Well, this is for Supreme Court 2011. My lord said. If my law says para 1314, Milos. 13, 14, 16, 13, Milos. Can I read, Milos? Para 13?
Yes.
Sufficient cause is an expression which has been used in a large number of statutes. The meaning of the word sufficient cause is adequate or enough, in as much as may be necessary to answer the purpose intended. Therefore, the word sufficient embraces no more than that which provides a platitude, which when the act done suffices to accomplish the purpose intended in the fact and circumstances existing in a case and duly examined from the viewpoint of a reasonable standard of a cautious man. This is the test, reasonable standard of cautious man. In this context, a sufficient cause means that the party had not acted in a negligent manner, or there was a want of bona fide on his part in view of the fact and circumstances of the case, or the party cannot be alleged to have been not acting diligently or remaining ineffective. That is what I'm trying to demonstrate. The time frame that I have demonstrated to my lords, June is request, it's not an IFI. His request, and he gets up for the first time in January 2021. However, the facts and the circumstances of each case must afford sufficient ground to enable the court concerned to exercise discretion for the reason that whatever the court exercises discretion, it has to be exercised judiciously. Now, 14. In Arjun Singh versus Mohinder Kumar, the court observed that every good cause is a sufficient cause and must offer an explanation for non-appearance. The only difference between good cause and sufficient cause is that the requirement of a good cause is complied with on a lesser degree of poor man that of a sufficient.
In order 41 rule 19, the phrase is sufficient cause.
Yes, madam. Yes. That's it. It's not a good cause. That's where I read it, Milos. Now, Milos, if my law has para 16.
Yes.
Sorry, para 16, Milos. In order to determine the application under Order 9, Rule 13 CPC, the test that has to be applied is whether the defendant honestly and sincerely intended to remain present when the suit was called for hearing and did his best to do so. Sufficient cause is thus the cause for which the defendant could not be blamed for his absence. Therefore, the applicant must approach the court with a reasonable defense. Sufficient cause is a question of fact, and the court has to exercise its discretion in the varied and special circumstances in the case and at hand. There cannot be a straitjacket formula for a universal application. Milos, then my loss can come to para 21, which is the relevant paragraph, Milos. On page 553, para 21. So far as has my lord got that para 21?
Yes.
So far as the High Court is concerned, it did not deal with the issue of service of summons or as to whether there was sufficient cause for the wife not to appear before the court at all, nor did it set aside the aforesaid findings recorded by the trial court. The trial court has dealt with only the aforesaid two issues and nothing else. The High Court has not dealt with these issues in correct perspective. The High Court has recorded the following finding. The order sheet of the original fight also deserves a look. The case was filed on 1/5/1989. It was ordered that the respondent be served vide process fee and registered AD for 6/7/1989. The report of the process server reveals that the process server did not identify the applicant and she was identified by the respondent himself. In the next date report, the appellant was identified by a witness. The registered AD mentions only one word, refused. It does not state that it was tendered to whom and who had refused to accept the notice. The case was adjourned to 8/9/1989. It was recorded the respondent had refused to take the notice. Only one word, refused, appears on the registered envelope as well. On 8/9/1999 itself, it was reported that the respondent had refused notice and permission was sought to move an application under Order 5, Rule 20 CPC. On 8/9/1989, an application under so was moved and it was ordered that the appellant be served through National Herald. The presumption of law, if any, stands rebutted by the statement made by the appellant because she had stated that she was staying in the said house of her brother for a period of 8 months. The version given by her stands supported.
What is the
by
contention in the main arbitration appeal? What is the issue?
Oh, main Milos is an
In very brief.
Milos arbitration. There was agreement for Milos to execute the water project in Mizoram. I have been involved since day one, so I can by one stage pumping, right, Milos? Later on, Milos, and the agreement was signed for only one stage pumping. Subsequently, Milos, it was moved from one stage to two stage pumping. And the whole project was executed for the two stage pumping, Milos. And there was no contract signed for the two stage pumping. So everything was done for the two stage, no contract signed. Rates were also totally different. What was there in the one stage pumping. Milos, based on equity, I don't know, Milos, and the rates and everything that has been. And there is no arbitration clause, Milos, for the two stage pumping as there was, because parties were contemplating to sign an agreement. However, they did not sign an agreement for reason best known to them, though it was sent to the applicant to sign it, but he refused to sign it for various reasons. If my laws are whenever getting into 37, I will demonstrate that. So, and the award is based on two stage pumping for which there was no contract, there is no arbitration clause. And the work done by him, admittedly on record, that everything that he executed for the project was for two stage, not for one stage. So it is in derogation of the contract first, Milos, because arbitral tribunal being a creation of the
Okay,
contract.
let us not go into it.
Yeah, that's where because it's a slightly, Milos, it has taken me a lot of time to understand one stage and two stage, but it is an admission by the parties that the previous agreement has become defunct. It cannot be acted upon. Therefore, we need to have a new
So
contract.
he had done his work and dues were not paid to him.
That's only for the two stage, not for the single stage. Not for the single stage. Because the contract was for single stage. Milos. There was two stage pumping.
Okay, let us not go into.
That's slightly right now, Milos, it's like technical tedious. So whenever I get an opportunity to assist this all.
Yes, anything else?
No, this is Milos, I'll close this para 21.
Yes, Mr. Vishwas. Whether the case was notified in the cause list.
It was notified in the clause list with a new number.
But the name of the parties,
Party was
and the
there, but the
council,
advocate also was not there.
council name,
Council was the council of a Ijol bench. He was not aware of it because it was not a transmission in the regular course. It was on my request. And the intimation was given by the registry of the Ijol bench that they are going to they are transmitting this to the registry of the Guwahati High Court. It was not a case that it was they are transmitting and these are the documents they are transmitting. And the address is not to me, it was given to the registrar Guwahati High Court. And it was intimated to me, a copy was given. Thereafter, there was no communication with an expectation that the
no,
registry
but
of the,
it was on your application.
it was in my application.
So you should have been vigilant.
I understand your point, Your
What-
Lordship, but
going
one thing
through the
before
cause
I go
list.
into the facts of the case. This honorable court, I will answer to your Lordship's query, but this honorable court, while condoning the delay of 126 days, had taken the same grounds to be a sufficient cause, Your Lordship. That order was never assailed by them before this court. They could have easily assailed that this cause, because the judgments they have placed before this honorable court was already placed by the bunch, whereby a combined argument was placed by them before this honorable court, before passing of the order which was passed in our favor by 1/8/25.
So is it your submission that when there is a case is dismissed for default and there is a delay in filing restoration petition, if delay application is allowed, it
I'm
means
not on that, Your Lordship. I'm not totally or not on allowed. What I'm trying to say, the sufficient cause which was there, this is the sufficient cause which I have again urged in my restoration application. My thing is the person before Your Lordship.
so your submission is that two different courts, coordinate bench dealing with
the same
different
subject matter,
applications
the
on same
substitution,
ground
same ground.
cannot reach into
What I'm
different.
trying to impress upon Your Lordship is the word sufficient cause is common in both the factors. In section 5
So
application,
say sufficient, prevented by sufficient cause, the phrase prevented by sufficient cause used in section 5
and
and order 41 rule 19
the word sufficient cause,
have same meaning.
that is my contention, Your Lordship. Once a coordinate bench, while condoning the delay of 126 days, while appreciating the same argument advanced on behalf of the respondents, taking note of that, had accepted the sufficient cause. My humble submission is this should have been the thing this honorable court may take into consideration the earlier observation. Now, even otherwise, Your Lordship, I would like to draw Your Lordship's attention to the fact what happened, Your Lordship. A case was pending for long before the Your Lordship is aware because when the case was received by the registry was never intimated to us because it is not a case where the interim by an order dated of the High Court or
No, is it the practice of intimating?
I'm saying because it was on my request, Your Lordship. My request, he had made a request to the
But
honorable-
notice to parties is given by registry
I have
in the
I have
cause
not done that
list.
Because this is a unique case in the fact because I made an application, the applicant made an application before the Honorable Chief Justice requesting the transfer because of the pendency. And that letter is Your Lordship will find at page 18. That was the letter on which the whole action was taken, Your Lordship. Thereafter, it was submitted by the applicant on 22/6/23. And thereafter, this honorable court will find that on 29/6/23, the Assistant Registrar Judicial, Ijol Bench, had transmitted these following records to the Registrar of Guwahati High Court. But thereafter, he was on the impression that it would be communicated that it has reached and it has been renumbered. Thereafter, I was not the counsel at that point of time, and though I was an engaged counsel on his behalf before the DRT, and I had
conducted some cases in his favor. Now, your lordship,
No.
I was made aware
No,
of,
I just want to understand one thing on facts.
yes, sir.
Your submission was that you did not know whether the
Records reached.
records reached the principal seat.
Yes, that is the only thing.
What is the mode? How you will know? You will
Because-
know by the cause list only.
No,
You have
cause
to-
list, until and unless it is listed, because each and every day from 29/6/23, your lordship, each and every day cause list, it was a transmission. When it reached, then I could have at least been made aware, I could have searched that it has reached the Guwahati High Court. That record has reached. It was the date when it was merely transmitted, whether it from Aizawl to Guwahati, it cannot be accepted that all the 4 corresponding files had reached on the same date. It was not, no intimation that it had reached, so that a bona fide digit.
No, but on your prayer, a matter was transferred.
On my prayer,
A
the
matter
record
was
was
transferred.
transmitted.
The normal course is for a council or a party to go through the cause list, whether it has been listed or not.
On which date I start looking for the cause list, because on 20,
That is
Nine-
his submission, that you waited till January.
yes, that is
Since-
his submission, that I waited till January because there was no update available. So
In between, on 3 occasions,
3 occasions it
it
came out.
was
on the list.
listed.
But the name of the local council was not local council, because the case, there was no local council at that point of time. Mr.
But name,
Malhotra name was being shown. And he is not a council from our Guwahati High Court principal bench, if I am not wrong, Your Lordship. So there was no search that is there. But what I'm trying to say is, after the appellant contacted me, I made a search, and on the day I received the information, on 5th of February, I got the information that it was dismissed. Your lordship will find on page 28 is the date of application I
Okay.
filed, seeking for the certified copy of the order by which it was shown to have been dismissed. Thereafter, subsequent thereto, after receiving this, I came to know that it was listed on 3 separate occasions. And then on search from, if your lordship sees page 22, I, on 8th of February, after 2 days, I made applied for the other earlier 2 orders. And then
division bench. Okay, I am reserving the order.
Because,
I-
before my lord, this is only one thing I wanted to. If my lord has, for 1 second, I'll take. In the 29th June later is addressed to Mr. Philip John, proprietor of the applicant, and to me. It is both intimation goes to him. It is on page 18, Milord, of my objection. The letter goes, I also appear as a department who is being accused every now and then of not following their matters, of prosecuting their. I also appear by watching in the cause list only on the first.
he had a local council, Mr. A. Das.
But I was appearing there,
Okay,
sir. He was
okay.
not available. He later on
I
came.
have a division bench matter.
Very well, Milord.
Heard
Lordship,
me.
then I may be permitted to argue further, because
No, I have heard both of you at length.
your lordship will see, your lordship.
I am fixing this for orders.
Okay.
Heard Mr. A. Bishwas, learned counsel for the applicant. Also heard Mr. What's your name?
Ajoy Roy, Milord.
Ajay
Roy.
Roy, A. Roy, learned counsel for the respondent. Let this matter be listed for delivery of orders on Tuesday.
Milord,
May-
if my lords can have it on 28th, Milord, if that's not inconvenient.
Okay,
because
28th,
yes, Milord.
28th.
Order will be passed, my lord.
No, I need to be. If there's any clarification, I would stand. I only
20.
because I have to be in before.
I'll get more time.
Yeah, I'm grateful, Milord. I'm grateful.
28th. Remaining matter will be shown as leftover.
My lord, item 36 is of
Great.
great urgency, my lord. It may be listed on 24/11. Item
Urgency-
36.
Urgency,
Grave urgency is there.
okay, 24/11.
24